law clerks are coming in. Judge, may I open court?
Can you just tell me how to make the people who are not visible,
Sure.
not on my screen?
Sure. If you put your cursor on the box next to mine, it should say Cliff Cislak on it.
Yeah.
When you do that, you should see
Yep,
a square.
got it. Excellent,
Okay,
perfect, thank you.
You're welcome, Judge. May I open court?
Please.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 20-5280, National Association of Postal Supervisors, Appellants versus United States Postal Service and United Postmasters and Managers of America. Ms. Graber for the appellant, Mr. Jenda for the appellees.
Good morning. When you're ready, Ms. Graber, you may proceed.
Thank you, Your Honor, and may it please the court. The Postal Service now concedes on page 17 of its brief, quote, NAPS may seek non-statutory review. That issue is no longer in dispute. The Postal Service then asserts that the statutory provisions at issue here are not limits on the Postal Service's authority. I'd like to spend my time today explaining why the statutory standards regarding supervisory differentials, compensation comparability with the private sector, and the rights of the postal supervisory and managerial personnel to be represented by NAPS are clear and mandatory, and how the Postal Service has violated those mandates. And our dispute with the Postal Service has two parts. The first concerns the 2016 to 2019 field pay package, which violates statutory mandates that the Postal Service pay a supervisory differential and that it establish compensation that is comparable with the private sector. Second, I will turn to why the statute permits NAPS to represent all supervisory and managerial employees, including postmasters, and why the Postal Reorganization Act does not distinguish between any category of supervisory and managerial personnel based on their reporting structure or any other category. Regarding the substance of the 2016 to 2019 pay plan, in the 1979 NAPS decision, this court held that the very same provisions at issue here regarding the supervisory differential and pay comparability establish standards that are clear and mandatory and reviewable under non-statutory review. This court held that the Postal Service was required to implement some supervisory differential and consider and fulfill in good faith pay comparability. The complaint here plausibly alleges that the Postal Service has failed to meet these requirements. As we point out on page 13 of our reply brief, this court already interpreted the Postal Reorganization Act to require that, quote, all, end quote, supervisory and other managerial personnel must receive some differential in compensation compared to the clerks and the carriers that they actually supervise.
But isn't there a differential? The problem is just simply that the employees, the clerk or other employees who are the supervisees can earn overtime that the supervisors can't?
No, Your Honor. As we explain at paragraphs 38 and 39 of our complaint, for thousands of supervisors, there is actually no differential at all, even before you take overtime into account. With regards to base pay, these supervisors earn less than the employees in the clerk or carrier grade that they supervise. And the reason is that the Postal Service has benchmarked a very low supervisory differential against a lower paid grade for the clerk employees, and thousands of supervisors represent higher paid carriers. So for these employees, even before you get into overtime, there is simply no supervisory differential. And this court was clear in the 1979 opinion that all supervisors must earn some differential compared to the employees that they actually supervise, not again just compared to one of the lower paid clerks or carrier grades in the system.
Do you think that our opinion held that every single supervisor has to have a differential, or else there's a violation of the statute?
That is the import of the court's remand to the Postal Service when it determined that it could not know from the affidavit that the Postal Service had filed whether, quote, whether all supervisory and other managerial personnel actually received some kind of differential. It's also clear from the statute, which does not say some supervisory and managerial personnel must earn the differential. So yes, I do think that all supervisory and managerial personnel must earn some differential.
But I guess the question is it when there's a comparison under the statute between supervisor and other managerial personnel and those they supervise, can that comparison be made in gross, or does it have to be made for every single office or every single supervisor? And I take it that the Postal Service is saying, well, it can be made in gross.
Again, I think turning to the court's 1979 opinion, what it said is that it couldn't tell, and it had to remand to the Postal Service. It could not tell whether all supervisory and other managerial personnel actually received some kind of differential. And it made clear that that differential should be pegged to the employees and the clerk and the carrier grades that the supervisors actually supervised. So it seems clear from that opinion and from the language of the statute that yes, it does have to be all supervisory and managerial personnel, not just in gross. And I think it's an issue that can also be, considered on the district court on remand as to which supervisory personnel, as to how the supervisory differential has actually played out.
I had a question, Ms. Graber, about one of the other issues about whether the association was unlawfully denied participation in setting the pay for the postmasters. And I guess in part, this is a question that I think part of which also applies to the headquarters and area employees. If the Postal Service has not presented a pay plan that covers the postmasters, does NAPS have any dog in that fight? I mean, they just haven't presented a plan, have they?
Your Honor, whether or not the Postal Service has presented a plan is not a fact pled in the complaint, but the consultation rights apply more broadly than just to individual pay plans. I can represent that the Postal Service did present a plan for the postmasters, and we would be able to add that to our complaint if necessary on remand. But if you look at the statute, Section 1004C requires monthly consultations to implement the provisions of the statute. And furthermore, consultation is required to implement for the implementation of any given pay plan, not just for the negotiation of the pay plan.
So I had a question about this statutory provision, the Section 1004B, which the Postal Service argues, I gather, Mr. Janda can correct me if I'm wrong, but I gather that they're saying at least it's susceptible of being read to set up 3 mutually exclusive categories. Your argument is no. I take it that you view them as nested categories. There's a supervisory organization that represents a majority of supervisors, or an organization other than an organization representing supervisors that represents 20%, at least 20% of postmasters, or a managerial organization other than a supervisor or postmaster organization representing a substantial percentage of managerial employees. When I read that, I actually don't see it as setting up 3 mutually exclusive categories. I see it as setting up nested categories. But my question is, why? It's really hard to imagine what this is about in the real world and why it would be written this way. That I take it to be saying postmasters can be part of a supervisory organization, managerial employees can be part of a supervisory organization. If it's a standalone postmasters organization, the representation only triggers if it's at least 20%. So why would they have these different participation thresholds, and why would they contemplate organizations that have amalgams of different types of employees to some extent, but than not in other ways. It's just, I'm having a hard time understanding it.
I do want to answer your question. I'm also mindful of my time, and I
We'll
want to
give you more time as needed. As long as the panel has questions, we'll give you additional time.
Okay, thank you, Your Honor. So some of the reason I think for the strangeness of the structure of the statute, as you've identified, is that the way the postmasters organizations were sort of shoehorned into the statute in 2003 was somewhat peculiar. But we agree with Your Honor that the nested structure is the reading of the statute that conforms to the statutory text. And what it does is that it gives all supervisory and managerial employees the rights to join together in one umbrella organization if they choose. And if they don't, then they can form more group-specific organizations, as you've identified. The fact of the matter is that there has never been a managerial organization. Employees have been satisfied with the representation that they've chosen through the National Association for Postal Supervisors and through the Postmasters organization. And that is permitted through the statutory structure that you've identified. What is very clear from that statutory structure is that there is no distinction made between employees who are headquarters and area employees and employees who operate in field positions. That's a distinction that the Postal Service has just read into the statute. And the Postal Service's position here is a fairly extreme one. What it's asking the court to do is give it the unreviewable total discretion to decide which employees can choose to be represented by NAPS and which cannot. And in doing so, it would give itself the power to not only deny NAPS arbitrarily, deny employees arbitrarily the right to be represented by the organization of their choice, but also really to destroy the supervisor's organization. And I want to emphasize that this is not a hypothetical. After briefing here was completed, the Postal Service announced a reorganization in which it realigned thousands of supervisory and managerial personnel who were in field positions into headquarters positions, and then initially took the position that NAPS could no longer represent those employees. What it is really saying here is that it has the power to totally destroy the supervisor's organization, and in doing so, it could totally eviscerate the entire statutory scheme, and that cannot be the law. I see that I am over time. Oh.
I have a series of questions, I guess, about related to this point. The statute doesn't define managerial employees, right?
Correct, Your Honor.
So how do we know what the difference is between a supervisor and a managerial employee?
As Judge Pillard identified, for the purposes of the question before the court, it doesn't actually matter because NAPS does have the power to represent all supervisory and managerial employees as the umbrella organization. So the distinction for our purposes today is one without a difference.
Well, I guess what I'm trying to get at is the statute speaks in terms of, in its definitions, under 1004I 2, it says members of the supervisor's organization means employees of the Postal Service who are recognized under an agreement between the Postal Service and the supervisor's organization as represented by such organization. I never saw in your complaint an allegation of who the Postal Service has agreed can be that your organization, your client can represent. I saw an allegation that the Postal Service said that they believed that you could not represent postmasters, but there's no allegation as to exactly who the Postal Service has agreed you could represent. Did I miss that?
No, Your Honor. There has not been a present agreement between the Postal Service and NAPS since 1981, when the previous agreement expired. But what is true is that under 39 USC 1205, the Postal Service has been deducting the dues of the supervisory and managerial personnel who have chosen to join NAPS from their paychecks. But there is not a present agreement between NAPS and the Postal Service. But if you allow the Postal Service to take the provision that you identified in 104I2, to give it the power to agree to anybody or nobody to be represented by NAPS, it's taking this narrow definitional provision and allowing it to totally override the entire statute. And that simply can't be right. This court has already found that whether or not the Postal Service has engaged in appropriate consultation is reviewable. And to allow the Postal Service a backdoor out of that consultation process and out of reviewability for avoiding the consultation process is entirely inconsistent with the statutory scheme and with this court's precedent.
What do you think I'm sorry, go ahead, Robert.
Go ahead.
No, I just want to make sure I understand. What do you think the issue is? I'm trying to make sure I understand your position. You're lumping managers and supervisors in one category, and what are you saying about postmasters? Are you saying they are managers and supervisors or not?
Postmasters are a subset of supervisory and managerial personnel under the statute, and therefore can choose to be represented by the supervisory organization as for that.
Just to be nitpicky about that, as I understand it, they are a subset of managerial and that some of them are a subset of supervisory. If you're a postmaster that doesn't have employees that you supervise, I had the impression that that was the case in some places.
That's correct, Your Honor.
Okay. So
and then your claim is there's a separate issue with respect to the headquarters and area employees is a different issue. You're saying that the Postal Service simply excludes persons who are working in those areas, right?
Mostly. It doesn't take a fully consistent position. It actually does recognize.
Right, so you're saying to the extent that they claim that those persons cannot be covered by the benefits of the statute, they're wrong, wherever it's happened.
Yes, Your Honor.
That's not the managerial supervisor postmaster issue. They're different issues.
The issue of the postmasters versus the headquarters and managerial employees are distinct. I do want to clarify, headquarters and area employees. I do want to clarify that headquarters and area employees are supervisory and managerial employees under the statute, as are postmasters.
Well, that the employees about which you're concerned are the supervisory or managerial employees at headquarters or in the areas, because there are employees at headquarters, presumably, who aren't managers or supervisors.
Presumably, there are employees at headquarters who are members of the senior executive service, correct? But
or who are under collective bargaining agreements.
That might be true, Your Honor. I'm not 100% positive about that. But yes, we are concerned about the...
That's a different issue, is all I'm trying to make sure I understand. You're saying they are claiming they can exclude anyone who's in a place called headquarters or area because that's where they are, no matter what their job is, right?
Correct, Your Honor.
All right.
So just as far as trying to figure out how this statute works, 1004H talks specifically about postmasters and postmasters organizations. And then when I look at 1004B and setting up the kind of three different ways that an organization can be recognized, I see that Congress use, when they talk about a managerial organization, they call it other than an organization representing supervisors or postmasters. Congress used an or, not an and. So I guess, unlike Judge Pillard, my inclination is to see these as three mutually distinct categories and not overlapping ones. Given that postmasters organizations seem to have kind of their own set of rules, and I don't really understand how those clauses in the parentheticals are doing any work unless you view these as three mutually exclusive groups. Tell me what's wrong with the way I'm seeing this.
So under the nested interpretation that we think is the more persuasive or the really only textual interpretation of the statute, those parenthetical clauses are still doing work because they say that the postmaster's organization or the managerial organization can form groups that do exclude, for the postmasters, that exclude supervisors, and for the managerial organization that exclude supervisors and postmasters. So then that does continue to give those clauses effect while still allowing employees to band together in the largest group available to them, the umbrella organization, which is the supervisory organization.
Well, suppose I believe that, well, maybe you do have an argument that that is a plausible reading of the statute, but I believe that the statute is ambiguous. If the statute's ambiguous, then how do we exercise non-statutory review when we only do so when the Postal Service is acting ultra vires? And we said in the earlier 1979 case that where something was ambiguous, it falls outside of ultra vires review.
So this court in aid association so first of all, I have a couple of points I want to make about that. First of all, this court in aid association for Lutherans made clear that the scope of review contemplated by the 1979 decision is in all respects consistent with Chevron. So even if you did find ambiguity in the statute, the Postal Service's interpretation of the statute must still be within the reasonable range of interpretations that Chevron allows. And the Postal Service's decision, particularly to exclude headquarters and area employees from being allowed to be represented by NAPS, is not within the reasonable range of interpretations because it reads something into the statute that simply isn't there. Furthermore, if you were to find the statute ambiguous in this way and allow the Postal Service to create these three very distinct organizations, then the postal managers would have no representation because there is no managerial organization and there never has been one as far as I'm aware.
But that's not a problem with the statute. That's just a problem with those employees needing to form an organization, and they can go out and do so.
But I do think that it sort of casts some skepticism on the Postal Service's position that Congress would have wanted there to be three separate organizations because it perceived there to be some inherent conflict between these groups. That's not how the statute or the Postal Service has been put into operation for the last 50 years. And
is there a conflict between the groups? I mean, what about the potential for conflict between managerial employees and their supervisors, for example?
That's not an issue that has any factual support behind it that the Postal Service has been able to identify. It's something that perhaps could be explored on remand if necessary. But the Postal Service can't simply assert it and declare that it must be true, particularly when the managers have been a part of NAPS for such a long time.
All right. Do my colleagues have any further questions?
I guess my final question is, I'm trying to get an understanding. Is there anything in your complaint or in the record that we can recognize that indicates that the Postal Service has acknowledged that NAPS can represent managerial employees?
So there was a concession by the Postal Service that NAPS can represent some of the headquarters and area employees. Whether or not the Postal Service considers those employees to be managerial employees, I think the complaint is not clear. So I think that's the best answer I can give to your question, given the posture of the case.
All right. Thank you, Ms. Graber. We'll give you a limited time for rebuttal. And in the meantime, we'll hear from Mr. Janda for the Postal Service.
Thank you, Your Honor, and may it please the court. Good morning. Sean Janda for the United States Postal Service. I'd like to start, if I can, by just taking a step back for a moment. And I think it's important to understand the context here which is that when Congress created the Postal Service as an independent agency in 1970, it decided that the provisions of the APA generally should not apply to the Postal Service's decision-making. And that was a decision that is consistent with Congress's broader determinations that the Postal Service has to have the freedom to control its costs and to manage itself efficiently, and that the Postal Service, and not the courts, and certainly not the plaintiffs here, are in the best position to weigh the many competing factors that are required for the Postal Service to try to achieve its many conflicting statutory goals of providing high quality and effective service, of controlling costs, of doing all of that while charging reasonable and just rates, and managing. Sorry, go ahead, Your Honor.
I'm sorry, I didn't mean to interrupt you. Go ahead and
No.
finish your sentence.
And just that that's sort of a multidimensional balancing act that the Postal Service, Congress has recognized, is in the best position to achieve.
So we have recognized some non-statutory review of the Postal Service and under this provision. And the district court suggested that it wasn't available here because the association had an option to request a second non-binding fact-finding panel. But you're not pressing that point on appeal.
We are not, Your Honor. So with respect to the pay package claims, which I think is what that mostly goes to, our claim is twofold. Our argument is twofold. One is that these provisions that NAPS relies on simply aren't limitations on the Postal Service's statutory authority. And so any claim under those provisions would not be cognizable in non-statutory review. And then second is that at the absolute most, and maybe this is what the 1979 NAPS decision recognizes, those provisions may require the Postal Service to consider those goals in good faith. And here the complaint makes clear that the Postal Service considered the goals in good faith. There's an explicit supervisory differential adjustment in the challenged pay package of 5%. And the comparability requirement, I think the complaint recognizes, not only does the Postal Service evaluate that internally, but in this case, the Postal Service hired an outside expert to conduct a survey to look at the comparability provision. And that's sort of above and beyond, I think, what this court and the Supreme Court has said that agencies have to do even when faced with the prospect of APA review. And it certainly suffices for the sort of low bar, good faith consideration of the requirement that is all that NAPS can get review of in this case.
You assert in your brief that the association didn't allege that the Postal Service failed to fulfill any of its obligations with respect to consultation and fact-finding, but as I read their complaint, they are alleging that, and that at a minimum, there, as you say, there's this sort of procedural requirement that the Postal Service at least consider in good faith the views of NAPS. And they do allege, and as I see in paragraphs 53 and 54 at page 17 of the appendix, that there was a failure in that regard. And what's your response to that?
So although NAPS does make those allegations in the complaint, there's not plausible facts in the complaint that could support those allegations. And so with respect to the comparability requirement, the survey itself is more than enough to satisfy the requirement to consider comparability in good faith. And even beyond that, the Postal Service has an in-house compensation and benefits department that tracks and evaluates the comparability requirement in those trends. And I don't think there's any sort of plausible facts to suggest that the Postal Service didn't consider that either when issuing the pay package or when going through the consultation and administrative mediation process. And to the extent that NAPS's argument is that a bare allegation of failure to consider is enough to survive a motion to dismiss in this context and to get into sort of evaluating the administrative record and doing whatever the next steps that they think would be appropriate in this litigation are, that just underscores how much NAPS's view of how this non-statutory review process ought to go would undermine Congress's determination that judicial review generally isn't appropriate.
But let me just ask, I mean, I don't think this is a separate count, but the association alleges that the Postal Service has broadly failed to engage with NAPS and failed to provide information required by the statute. They haven't furnished details of their decision to implement their pay programs. They haven't provided information on which they're based, but perhaps more sort of significantly from their perspective, that when the Postal Service has rejected their recommendations, the Postal Service has an obligation to provide reasons to NAPS. And my understanding is that you don't dispute that that hasn't taken place, to provide an explanation to the association if it rejects any recommendations. Am I wrong? Or do you think the recommendations are illegitimate because they purport to represent members they can't represent? Or what's your view of why those explanation obligations have been met?
So I think initially that's not an issue presented in this appeal. NAPS hasn't briefed that issue, hasn't pressed any argument in this appeal on that issue. That being said, to the extent that the Postal Service is required to provide reasons, I can tell you it's not alleged in the complaint, but the Postal Service, when it issued the final pay package, provided, I think, an 8-page letter that goes through the fact-finding panel's recommendations, explains which ones is accepting, which ones is rejecting, and provides written reasons for each of those. And so, again, it's not alleged in the complaint, but the Postal Service did provide that written sort of decision explaining what it was and wasn't accepting from the fact-finding panel. And so, to the extent that is a statutory requirement, the Postal Service certainly fulfilled it in this case.
Is that letter before us? Can we consider it? Was it incorporated into the complaint?
So, Your Honor, our argument might well be that had NAPS pressed that claim or pressed that argument, that the letter is appropriately incorporated into the complaint and could be considered on a motion to dismiss. We haven't put it in the record. It wasn't in the record of the district court. It's not in the record before this court because NAPS hasn't pressed that as an independent claim.
I intended to ask appellant's counsel that, and I forgot, but I don't see a separate count in the complaint saying that the Postal Service violated the statute by giving an inadequate explanation. And I also didn't see any requested relief in the complaint of requesting a remand or anything relating to requiring the Postal Service to provide more robust explanation for rejecting the recommendations. So that's why you're saying that the issue isn't before us.
That's correct, Your Honor. I think neither in the complaint nor certainly pressed in NAPS's brief in this appeal. And so, even if there are portions of the complaint that gesture in that direction, it certainly hasn't coalesced into an argument for relief in this appeal.
Counsel, my understanding is fairly straightforward that the obligation with respect to pay differential is as to supervisors and the employees they supervise, and you haven't satisfied that. You haven't shown that you satisfied that requirement. Maybe in some cases you have, in other cases you clearly have not. And so there's certainly remand there. Am I wrong?
Yes, Your
Honor.
Honor.
If that is my interpretation of the statute, then it has to go back on that, right?
So I cannot tell you that every supervisor earns more in base pay than every employee they supervise. And if that's your interpretation of the statute, then this ought to go back. But that's just not.
It really is not as onerous as you're suggesting, unless the Postal Service is more screwy than I would have imagined, because most employers put supervisors in categories as to their employees. So you're not talking about Joe Blow and the 2 people he supervises. That's not what the inquiry would be. It would be whether certain groups of supervisors are making more than the groups of employees that they're supervising. It's not an onerous requirement. You either did it or you didn't. My understanding of the record, just so you can know what my concerns are, is that you certainly have not shown that. It may be the case in some instances, but you have not satisfied that requirement, if I am right that that is the requirement. So that's one thing, right?
So I think that depends on exactly how Your Honor understands the requirement. So what the Postal Service did in this case, and what it's done, my understanding is for a long time, is it chunked up supervisors into different groups. And for each group, picked a benchmark supervisee employee, generally the sort of most populous supervisee employee, and then added the supervisor differential to that employee's base salary to create the minimum salary for the supervisor. And there may be some supervisees in particular circumstances who earn more in base pay for whatever reason than their supervisor. But I think the NAPS's argument is that that's not okay, that every supervisee must make less than his supervisor. And that's,
it does seem like if the statute says that employees and the employee, there should be a differential between supervisory employees and the employees they supervise, that the methodology that you describe is fine up until the choice of some median or, plurality of the supervisees. Why wouldn't the necessary benchmark be the highest paid of the supervisees, since the point is there has to be a pay differential between the supervisory employees and the employees they supervise?
So I think 1004A is the relevant statutory provision, Your Honor. And all that says is that, number one, it's a policy goal, which
right.
But beyond that, all it says is that it shall be the policy of the Postal Service to provide adequate and reasonable differentials in rates of pay between employees in the clerk and carrier grades and supervisory and other managerial personnel. And so the statute speaks in gross terms between the two categories. The Postal Service, in this case, it broke it down even further by looking at, I think, 4 different groups. But that's my understanding. I don't want to say that is definitely correct, but by a number of different groups of supervisors and sort of their supervisees. And that, I think, is more than enough to satisfy the statutory requirement.
Well, that policy argument, you're not really pushing that, are you? There's another part of the statute that makes it clear. It says shall.
Actually,
Go ahead.
I'm sorry, I don't think that's correct, Your Honor. So I'm not sure if you're looking at, also, I'm not sure which part of the statute you're looking at. 39 USC 1001C says the Postal Service shall achieve and maintain compensation that's comparable to compensation. That, again, it is a policy goal. The title,
with or without, it doesn't have a policy.
So the
mandatory language.
So the title of Section 101 is Postal Policy, and I think it's obvious from the context.
Then it says what postal policy will be. The Postal Service shall achieve and maintain comparable compensation, et cetera. Doesn't say the Postal Service will strive to reach a policy of. It says they shall.
I think in the context of Section 101, if you look at it, it's, I believe, 7 different sort of broad policy goals that the service should be operated as a basic and fundamental service, that the Postal Service shall provide a maximum degree of effective and regular postal service to rural areas. And I think in that context, it is clear that these are broad goals that the Postal Service is required.
Is that the way we initially construed the statute, to say, do your best? I didn't think that was our initial interpretation of the statute many years ago.
So I think this court's interpretation of the statute is that the Postal Service has to give sort of good faith consideration to these goals, and has to arrive at a result that it thinks in good faith appropriately balances the goals. And again, here, I don't think there's any question that the Postal Service did that. There's an explicit supervisory differential adjustment in the package. And on the comparability piece, the Postal Service went so far as to hire an outside expert to look at comparability of pay between the Postal Service and the private sector.
Yeah, but it could, I think their allegation on comparability is and I thought our court had spoken to that as well. There is an obligation to attend to this. And I thought their claim is, which is not frivolous, that it was bogus. There wasn't any serious effort to look at the private sector and reach comparability determinations. We've certainly said there is such an obligation under the statute. You're right, where you end up, if you've done it in good faith, you certainly have a whole lot of room to run, but you certainly don't have a whole lot of room to just do it willy-nilly and be subject to a claim that you didn't do this seriously. You haven't seriously looked at the private sector to make the determination the statute requires.
So I have 2 responses to that, Your Honor. The first is that I think there's just no question in this case that the Postal Service looked at these obligations in good faith. They hired an outside expert on comparability to evaluate, to do an independent study to evaluate the comparability of the 8, my understanding is most populous NAPS representative positions. And that goes well above and beyond what this court or the Supreme Court has held is required, even under APA review. And so that, I think, absolutely satisfies whatever good faith requirement there is. And to the extent that even in light of that study or in light of the explicit supervisory differential adjustment, NAPS's conclusory allegations that the Postal Service didn't do it in good faith could be enough to get them over a motion to dismiss. That just undermines Congress's judgment, which I think this court sort of articulated very, very clearly in the 1979 NAPS case, that this isn't something that is generally subject to judicial review.
So I appreciate that there was some effort made, and the allegations before us are that the assessment was very, very partial because they looked at 8 of approximately 1,000 positions. And I take it your pushback on that as well. There were 8 significant positions for purposes of NAPS. But the other thing they claim is that the Postal Service substantively just does not meet this requirement because they're not giving annual raises. So they're just in a really structural and persistent way tying into a approach to pay that just is not comparable. And that the statute requires that the Postal Service shall achieve and maintain compensation that's comparable to the rates and types of compensation paid in the private sector. So how is it comparable, and how can it be maintained as comparable if there's not even increases, periodic increases that are standard in the private sector?
So I think, again, sort of quibbling around the edges of the specific portions of how pay is calculated, and whether that's bonuses, whether it's annual raises, whether it's locality pay, none of that is in the statute. The statute doesn't require any specific parity between the Postal Service and the private sector, and it doesn't require any sort of particular features of the pay package to achieve that goal. And so to the extent that the Postal Service sort of evaluated comparability and made a good faith determination, which is clear from the record they did in this case, that the package that they were issuing sort of was a good faith effort to satisfy the comparability requirement.
I mean, you refer to good faith, and I don't have any reason to question, and as a subjective matter, any good faith on the part of the Postal Service, but they didn't need to say you need cost of living increases, you need regional adjustments for where it's really expensive to live, or because they use a shorthand comparable to the private sector. So why doesn't, if there's no explanation of, oh, we do that in this different way in our pay structure, then how can the association employees, members, be confident that it actually was even sought to be comparable?
So, I think there is, of course, a extensive consultation and administrative mediation process that the parties engaged in this case. And that's the process where the Postal Service can provide reasons to NAPS. It did provide reasons to NAPS in this case.
But even the fact finders there thought that the Postal Service had not fulfilled its obligation. So I'm not sure that supports you.
So that was the finding of the mediation panel, but the Postal Service, even after that finding, provided a letter to NAPS explaining how it had considered the requirement and why it believed it met the requirement. Mm-hmm. And I think, again, this all goes back to the fact that Congress has determined that the Postal Service is in the best position to weigh these competing factors.
Right, if it's weighing them at all and giving an explanation. I know we've kept you up here a long time. I had really wanted to hear your view, though, on the categories that the association claims were just completely categorically overlooked. What is the position of the Postal Service on the headquarters and area employees being excluded from the pay package, and what is the position on the statute that allows postmasters to be represented by a supervisory organization?
Yes, Your Honor. So starting with the headquarters and area employees, the Postal Service's view is that most headquarters and area employees are not eligible for representation by NAPS as they're non-supervisors. That being said, even the complaint recognizes that the Postal Service has recognized that some area and headquarters employees are supervisors, are eligible for representation, and has excluded those employees from the 2016-19 area and headquarters pay package. And my understanding is included those employees in the recently issued pay package that was developed after consultation with NAPS. And so the Postal Service isn't drawing any absolute distinction between area and headquarters employees and field employees in terms of eligibility for representation. And again, I think it's under sort of non-statutory review. It's NAPS's burden to show that the Postal Service has plainly violated the statute. And there's just nothing in the complaint that explains sort of which employees NAPS thinks have been improperly excluded from representation.
I thought it was pretty clear. I thought it was pretty clear. They represent supervisory, postmaster, managerial employees. And as you just said, the Postal Service excluded them from the past pay package to the extent that they were area or headquarters employees, even if they were, or maybe because they were represented by NAPS. So there's like a carve out there saying we are generally looking at area and headquarters employees, but if you happen to be NAPS represented, we're not going to include you. Is that right? And I'm trying to make sense of that.
So my understanding, Your Honor, is that there are sort of two separate pay packages. So one is for area and headquarters employees that carves out those employees who are represented by NAPS, and the other is for field employees and those area and headquarters employees who the Postal Service recognizes as represented by NAPS. So those are the two pay packages, and NAPS is consulted on the pay package for field employees and for area and headquarters employees who are represented by NAPS. And so the distinction that the Postal Service is drawing is between NAPS represented employees and non-NAPS represented employees, or employees who the Postal Service doesn't think are validly represented by NAPS. And I think you can look through the complaint. There's just nothing in the complaint that says,
so
here
run
are
that
the
by me. I'm sorry, run that by me again. So there are two pay packages. One is area and headquarters employees, and the other is field employees.
Correct.
And those pay packages generally include supervisory and non-supervisory employees, generally, but they exclude supervisory and managerial employees represented by NAPS?
No, Your Honor. I'm sorry if that is what I said. So my understanding is there are two pay packages. One is area and headquarters executive and administrative service employees, but not those that the Postal Service recognizes as represented by NAPS, just the other ones.
And when you say EAS, that means typically supervisory managerial.
I think not necessarily, Your Honor. There are,
but a bunch of them are.
Some of them are, yes.
Okay.
My understanding is many fewer in headquarters. There are many more, whether it's sort of SES or whether it's professional or administrative employees rather than supervisors and managers. And then the other pay package, and this is the one that was issued, sort of the challenged one, and then also the one was recently issued that we filed a letter about. That pay package covers all field EAS employees and the headquarters and area EAS employees who the Postal Service believes are validly represented by NAPS. And NAPS has been consulted on that package. I don't think there's any question about that. And so the
second package, just so I have it right, is the field employees and the area and headquarters employees that NAPS represents?
That is correct, Your Honor. That is my understanding. And I think at the end of the day, the sort of fundamental point is that just looking at the face of the complaint, NAPS concedes that the Postal Service has excluded from the unconsulted package those employees who the Postal Service believes are represented by NAPS. And there's just no factual allegations in the complaint that could support the notion that the Postal Service has plainly sort of violated the statute in drawing the distinction that it drew.
So it bunches all the NAPS employees, whether they're area and headquarters or field, all the NAPS represented employees into the field package, just as a way of saying everyone we're dealing with the NAPS is going to be in the field package, even if they're not field employees.
That is my understanding, Your Honor.
All right.
And the problem is we don't know who I'm listening to you carefully. We don't know, you say who the Postal Service determines the union represents. But in that answer, I think what you're saying is you're making some determinations with regard to certain supervisors and managerial employees that you will not recognize, or you say the union cannot represent. It's totally unclear. Are you conceding now? Let me see if I can clear it up this way. Are you conceding that the union can represent supervisory and managerial employees in these offices, in headquarters and area offices? There's no doubt in your mind they can. They represent them. You have to consult with them. You agree?
So, Your Honor, my understanding is
take my question. I want you to answer my question. Are you conceding to the court that yes, the union can represent managerial and supervisory employees in any area and headquarter situation? We are not objecting to that, and we have an obligation to consult with them if they do represent those employees. We cannot exclude from representation employees who are supervisors or managers merely because they are in area and headquarter positions, right? Yes or no? Are you conceding that or not?
So I think there were two different questions there.
No, there's not. There really is not. Are you I'm going to try and make it one question because I really am curious what your answer is. Are you conceding that the union may represent supervisors and managers in area and headquarters positions, and that the Postal Service has an obligation to consult with the union with respect to those employees?
Our understanding of the statute is that employees may not be excluded from valid representation merely because they are headquarters or area employees.
Do you concede that supervisors and managers in headquarters and areas positions can be represented by the union, and you have an obligation to consult with the union with respect to those employees? You concede that or not?
I don't think I can broadly concede that, Your Honor. I can
Why?
concede that because I think supervisory and managerial employees is a very broad category. I think it's not necessarily clear from the statute that NAPS is even entitled to represent managerial employees as distinct from supervisory employees. And my understanding is that the Postal Service has sort of recognized a list of positions at headquarters and area employees who NAPS validly represents. It has excluded those.
Yeah, well, that's self-serving. Who validly represents. That's the whole point. You either everywhere else, if they're supervisors and managers, they're not in headquarters, they're not in area. You're conceding, you're not doubting that the union may represent those employees and that you must consult with respect to them, right? Everywhere else, if you're a supervisor or a manager, the union can represent those employees and you must consult, right?
I do not know that that is correct, Your Honor.
So just to focus it, I think on you were resisting managerial, and I think that gets back to the three different categories.
Correct.
And whether they're mutually exclusive or nested. So let's just keep it simple and say supervisory employees that are headquarters and area employees. Those are people that NAPS is entitled to represent, and with respect to which the Postal Service therefore has an obligation to inform, discuss, consult.
So we have
agree with that?
We have not made any argument that supervisory employees at area and headquarters are not validly represented by NAPS.
No, could you just no?
But you
really
also
would be easier for no, Judge Phillip, answer Judge Phillip's question. Do you agree with what she just said? Yes or no? Because then that takes a big issue off the table for me. Because if whoever is writing this, that's pretty easy. That ends the big question. We agree or not?
I don't know that I can broadly agree to that statement. What I can say is that there is not a single thing in the complaint that makes out an allegation that there is some group of supervisory employees that are at area or headquarters that are not being consulted or who are not being covered by the consulted pay package.
I think there is an allegation.
Certainly is an allegation.
To that regard, they say that the pay package, the 2016-29 pay package, concerned only association members designated as field employees, excluding 7,500 of its members that the Postal Service treats as headquarters or area employees. And so they're saying we have a big chunk of membership that, you know, I recognize there's a separate legal position that the Postal Service is taking with respect to managers, but that includes managers and supervisors that we represent that are headquarters and area employees and everything else the Postal Service says. And you're not including them and you're not recognizing us.
And I thought the fight was over. I thought your position somewhere along the line was that you were trying to distinguish between supervisors and managers on the one hand and professional and technical on the other. I thought that was the fight, but maybe I've just completely missed this case. That's why I'm trying to get you to either concede or not that the fact that you're a supervisor and manager and you're in an area or headquarters position, you still can be represented by the union and the Postal Service must consult.
So I don't think I have the ability to broadly concede that. But
I mean broadly. I don't want you to do it broadly or narrowly. I just want you to concede that sentence. That's all.
I do not believe I can concede that.
And why is that wrong?
So I think there's two things. One is that this court doesn't need to get into that.
No, counsel, please, indulge me. Okay, indulge me. Forget whether I have the authority to decide something. I'm trying to understand the case. So I don't want you to tell me what I can and cannot decide. Just tell me whether you agree that the union can represent area supervisory and managerial employees, and the Postal Service is obliged to consult with respect to those employees if the union does represent them.
So I agree that as the mere fact of being an area or headquarters employee does not exclude someone from valid representation. I think the fight in this case is over the exact scope of that valid representation with respect to area and headquarters employees. My understanding is that the Postal Service has recognized a set of area and headquarters supervisors as validly represented by NAPS and has consulted with NAPS with respect to those employees. And there's
in what context? With respect to what pay package? With respect to the field pay package?
So my understanding, Your Honor, is that those employees were carved out of the 2016-19 area headquarters package and were included in the recently issued 2021 sort of, I don't know that it's called the field pay package, but it's the pay package that includes all employees that the Postal Service recognizes as represented by NAPS. And
okay. But before your 28J letter, we had nothing showing that they were included in anything.
Correct, Your Honor. But I think the complaint admits they were excluded from.
Right. And so your view is if they were excluded, then there's no, we'll just put these people by the side of the road and then we won't violate our consultation obligations because we're just not giving them a package. So
I don't think that's what NAPS's claim is getting at. I think NAPS's claim is focused on the issuance of the 2016-19 area and headquarters pay package. And my understanding, I mean, if I could just back up for a second.
And your view is, so your threshold view is they don't have a dog in that fight because that doesn't even cover any of their people?
It
doesn't actually affect the terms and conditions of their employment because even though they may work in headquarters or work in what for other administrative purposes USPS denominates area, they actually are treated for purposes of a pay package as not there. And therefore they don't even have standing to kind of address the headquarters and area package. Is that right?
So I don't think it's an issue of standing, Your Honor.
Or, I mean that loosely. I mean that they're not included and so they're not harmed in your view?
Yes, sort of. So if I could just back up for a second. This is my understanding of NAPS's claim. NAPS says you issued this 2016-19 area and headquarters pay package for area and headquarters employees. You excluded from that pay package certain employees that you recognize are validly represented by NAPS. That is true. But I think what NAPS's claim is that they believe they represent additional area and headquarters employees who were not excluded from the pay package, and that they ought to have been consulted with respect to those employees. And that is how I understand NAPS's claim.
And when you say that, the additional employees, you're talking about managerial employees, and this is because of the tripartite reading under 1004 I2 or something?
So I don't have the information on sort of the exact employees who were excluded and who were included and who NAPS believes they represent. And I think fundamentally that is a problem with the complaint. The complaint doesn't include, it could include a paragraph that says, here are the 5 job titles of employees at area and headquarters that we think we represent. Here are their job duties. Here's why we validly represent them. And we should have been consulted with respect to them. The complaint doesn't do any of that. All it says is that we disagree with who you excluded. But that's not enough to plausibly allege a plain violation of the statute because there's just no supporting facts.
All right. I really also want to hear your view on the provision that requires the Postal Service to recognize associations of its employees. Because as I mentioned, this is 1004B. Upon presentation of evidence, the supervisory organization represents a majority of supervisors, that an organization represents at least 20% of postmasters, or that a managerial organization represents a substantial percentage of managerial employees, such organization shall be entitled to participate directly. And then there are these parentheticals that I left out on that reading. Supervisory organization represents a majority of supervisors, that an organization other than an organization representing supervisors represents at least 20% of postmasters. Implication, to me, clear, unmistakable implication of the parenthetical is that an organization that represents supervisors could include postmasters, because they're basically saying if you're postmasters and you want legitimate representation, if you're on your own, you have to have 20% of postmasters. If you're folded in with an organization representing supervisors, that limitation, that threshold does not apply. You can just be part of a supervisory organization representing a majority of supervisors and whatever portion of postmasters or managers want to be part of it. And so too, on the third clause, a managerial organization other than an organization representing supervisors or postmasters, which have their own membership thresholds that we've just told you about, managers can be part of an organization, and the Postal Service will have to consult with an organization that represents a substantial percentage of managerial employees. Why is that not the clear and, in fact, only way to read the statute? Because if what they wanted to say was these 3 groups can have mutually exclusive organizations and they have to be specific to these job categories and we'll talk to them, that would be like way easier to say in a different way. The only reason it would be done in this way is if they're nested in the way I mentioned.
So the statute is certainly not a model of clarity, Your Honor, and we recognize that. That being said, we think a couple features of the statute point in the opposite direction, and it's certainly not the case that the only reasonable reading of the statute is as nested. So there's a couple things. So one, as Judge Wilkins sort of pointed to earlier, is that I think that second parenthetical that says other than an organization representing supervisors or postmasters, which seems to suggest a distinction between an organization representing supervisors and an organization representing postmasters. And then second, and more broadly, is that this provision, I think the only reason to enact it the way that Congress enacted it is as recognizing that there are sort of supervisory, postmasters, and managerial organizations, and that the interests of those employees may conflict, and the purposes of effective consultation may not be served by allowing the same organization to represent both.
So it's your position also that the intervener who intervened in your favor, which purports to represent managers, is illegitimate as a representative of those managers as well.
So, Your Honor, the statute sort of carves out managerial organizations as a separate organization.
Yeah.
My understanding
under your reading.
Right, correct. My understanding is that, as Ms. Graber said, there has not ever been a managerial organization. There is not a managerial organization. And in recognition of that reality, my understanding is that the Postal Service has been willing to consult with sort of non-managerial organizations with respect to their managerial members.
Well, there's also never been a separate postmasters organization. There's a postmasters and managers organization, right? There's a postmasters and managers organization. And there's the National Association of Postal Supervisors, which purports to represent all 3 tiers to the extent they want to be represented by it. So your view is that the postmasters and managers, that the Postal Service actually cannot negotiate with them about the managers because of the way you read 1004B.
So there's a difference, Your Honor, in our view, between who the Postal Service may consult with an organization about and who an organization is entitled to be consulted about. And I think as a practical accommodation, the Postal Service has traditionally been willing to consult with NAPS or with the UPMA to the extent that those organizations represent managers or claim managers as members. The Postal Service has been willing to
there, it really doesn't matter that there's a conflict of interest between the postmasters and the managerial employees under their purview who help them run the post offices, whereas there is a conflict that would prevent reading of the statute as establishing these organizations as nested.
I don't think that's necessarily the case, Your Honor. I think the Postal Service's view is that, and I don't know what would happen or what the Postal Service's view would be if there were a managerial organization, but rather than cutting off their managerial employees from any consultation whatsoever, the Postal Service has been willing to make an accommodation, even if that accommodation is not one to which NAPS or PMA are entitled by the statute.
We've really, I'm sure, kept you longer than you anticipated. I want to make sure that
I'd like to ask one question. How does the Postal Service think that a managerial employee is defined and can be distinguished between a supervisor?
So the statute, my understanding is, does not define managerial as distinct from supervisors. And I think because there is no sort of separate managerial organization, I don't know that the Postal Service has ever had to articulate a clean dividing line beyond sort of the plain text difference between supervisor and manager. And so that's just not an issue that I know if the Postal Service has sort of articulated an understanding or what that understanding is.
All right, thank you.
Thank you.
Thank you, Ms. Kraber. I don't believe you have any rebuttal time because we kept you up for more than your allotted time, but we'll give you 2 minutes for rebuttal.
Thank you, Your Honor. And I'll do my very best to stay within those 2 minutes. There are 3 main points I want to make sure I hit. The first is that the 1979 NAPS decision was very clear that it is not just that the Postal Service must consider the statutory factors, but that it must fulfill them. So it is not enough for the Postal Service to allege, by the way, drawing inferences in its favor from the complaint, that it has given good faith consideration. The second point I want to hit is regarding pay comparability. What NAPS has alleged is that the Postal Service engaged in a post hoc survey after it had already implemented the 2016 to 2019, or established the 2016 to 2019 pay package. It did a post hoc survey of only 8 of 1,000 positions. And even for those 8 positions, that survey could not allow it to fulfill the statutory mandate because 101C and 1003A refer to rates and types of compensation and benefits, telling the Postal Service to look at total compensation. And the Postal Service never studied total compensation for any position. And the court cannot simply allow the Postal Service to draw inferences in its favor that it must have because it has unpled internal expertise. Third, regarding this issue of the headquarters and area employees, we do not share the Postal Service's understanding that any 2016 to 2019 pay package covered the headquarters and area employees represented by NAPS. And under 1004E, the Postal Service was required to issue a pay package and consult with NAPS during a certain period of time after it issued the pay package for the collective bargaining groups. I do want to make sure I point the court to paragraph 57 of our complaint, where we allege that the employees represented by NAPS that the Postal Service has refused to recognize include employees who perform both supervisory and managerial responsibilities. The Postal, and so just to wrap up here, the Postal Reorganization Act anticipates and desires all supervisory and managerial employees to have representation, and thousands of postmasters and headquarters and area and other supervisory and managerial employees have chosen NAPS as their representative, and we ask this court to allow them to do so. Thank you.
Thank you. We'll take the case under advisement. Thank you both for your energetic responsiveness to our questions.
Case number 20-1319 et al. Wendt Corporation petitioner versus National Labor Relations Board. Ms. Schroeder for the petitioner, Ms. Rajapaksa for the respondent.
Good morning, counsel. Ms. Schroeder, you may proceed when you are ready.
Good morning, judges. May it please the court. As noted, my name is Ginger Schroeder of Schroeder, Joseph and Associates, and I represent the petitioner, Wendt Corporation. Almost 20 years ago to the day, Judge Edwards heard oral argument in a case where he noted that the NLRB in a substantive area of law had, quote, come full circle. And when he wrote the decision in that case, he penned an observation that has often been cited in cases by the DC Circuit and other courts, that it is a fact of life in NLRB law that certain substantive provisions of the NLRA invariably fluctuate with the changing composition of the board. And I would submit that nowhere is that inconvenient fact of life more apparent than in the development of the controlling case law on the issue of past practice, and particularly with respect to the factual issues governing my client's obligations under the temporary layoff that occurred in 2018. I think over time, particularly the past decade, employers have been wondering, what set of facts are actually going to privilege them to claim a past practice such that they can act consistent with that and have the privilege of, unilateral action or unilateral imposition. And I think that looking at the last 10 years of case law, discerning a past practice is it's a bit like changing a tire on a car rolling downhill. So we have the backdrop of Katz. And if you look at the decision in Raytheon, you'll see that the myriad of cases that have dealt with this. It says, in sum, and for the reasons stated above, we overruled DuPont as well as Beverly 1 and Registered Guard, and we reinstate Shell Oil, Westinghouse, Winn-Dixie Stores, Beverly 2, Capital Ford, and the Courier Journal cases. Finally, when you look at the transition of those cases over time, just 7 weeks before my client had the temporary layoff, we have the decision in Raytheon. And that, I think, privileged my client to deal with the layoffs in the manner that it did. In Raytheon, the court declared the DuPont standard very unworkable. And in the numerous decisions where boards and courts have interpreted Katz, which is the Supreme Court precedent in this area, they really all support the view that when determining whether an employee action constitutes a real change and thus triggers the obligation to provide the union notice and an opportunity to bargain, really the only relevant question that we should be asking is that action similar in kind and degree to what the employer did in the past, such that employees would understand, what was going to be the circumstance and what was going to be the response. In Raytheon, the circumstances in that case.
I don't see any change or whipsawing back and forth in how the board has treated the focus of the inquiry. So here the claim is that the employer unilaterally transferred work out of the unit. Wendt's response is, we have a longstanding practice of allowing some workers outside the unit to do some of the work that the unit employees do. And when we promote these 3 shop employees, they're consistent with the past practice of allowing non-unit employees to do some work. Board says, no, you've transferred work out of the unit by creating new positions and promoting people into it. Past practice supporting that, I did not see Wendt as providing evidence of any comparable prior removal from the work unit. So I know that's the second reliance that you have on past practices, but there isn't any past practice referred to. Is there in the record of Wendt doing that kind of thing, removing work from the unit?
So with respect to I believe Your Honor is referring to the supervisors, the creation of the supervisory positions and the failure to backfill the positions of the lead men.
Or failure to negotiate over that change. Yeah.
Correct. That the board would have to show that there was a material loss of work. And if you look at Appendix 72 and Appendix 792 through 795, that demonstrates that the unit work that was performed by those employees combined to only 1/2 of a full-time position.
Right.
So that's not a material change.
So that's really, with respect to that, that's the position that you're relying on, is just that it's de minimis, not that there was in fact a past practice that was acceptable on this point.
Well, we certainly did provide some evidence in the record relating to other supervisors who performed work. For instance, in the
right, but not that work was taken out of the unit by a change in the way the workforce was organized. On your principal argument about relying on past practice, it's about the layoff practices.
Correct.
And again, when reading all of the board's precedent as, not a zigzag, but just a body of precedent, it does not appear that 2 temporary layoffs over 17 years is a kind of established past practice. At least none of the cases that I read, Raytheon or Katz or Mike Sells or the cases that they themselves cite seems to recognize that kind of intermittent and far in the past practice as the kind of what do they call it? Dynamic status quo.
Dynamic status quo, Your Honor. Yes.
That the past practice doctrine is meant to embrace.
So I'd like to address that because you really, Your Honor, get right to the crux of the problem. The administrative law judge in this case did not actually analyze at all the issue of the past practice of layoffs, and in fact gave very short shrift to it. That caused the board to almost do really a de novo review. They said themselves that they were going to do a careful review of the record. Well, their careful review of the record had factual inaccuracies that were not supported by the record. So if we look at Appendix 612 through 613 and 824 through 843, we will have layoffs that occurred in 2001, 2002, 2003, 2005, 2009, and 2015, all predating the 2018 layoff. Very conveniently, when the board did look at the layoffs that it actually found in the record, it dismisses in like or substance the 2015 layoff by saying, well, that was permanent in nature, so therefore it doesn't count. I'm suggesting to this court that when we're looking at the issue of past practice, we have to look at the circumstance and we have to look at the employer response. The circumstance that Wendt is faced with, being in a very cyclical recycling industry, is downturn in work beyond its control. The recycling industry goes up, it goes down. How does Wendt respond to that? By laying off employees when it hits the valleys, and by taking them back when it hits peaks, or even hiring temporaries when it hits peaks. The board did not deal with those layoffs at all. So if we look at 2001, we had 5 people laid off. 2002, we had 2. 2003, 1. 2005, 2. 2009, 6. And 2009, the board would like you to ignore the 2009 layoff as well by saying, well, there they laid off both unit workers and supervisory workers. So it's different in nature and kind than the other layoffs. And what I'm suggesting—
It's interesting you're referring to, not even in your brief to us do you refer to all of those. You reference, I think, 5 layoffs. The board says 2002 and 2003 layoffs. There were no sizable group of people. I didn't see your brief making any serious effort to combat the distinction the board relies on there. And we review the board, especially on this kind of fact-bound, record-bound issue, just for substantial evidence and with a lot of deference. So when you bring up, straight from the record and not even in your brief, some larger body of putative practice in this area, I don't really see precedent that allows us to reach through what the record, the argument you made in your brief to us, and just sort of consider that de novo.
With all due respect, Judge Pillard, what I just read was from my reply brief, down at the bottom of page 3, going to the top of page 4, and I specifically cite those pages in the appendix that have those exact documents that were respondents' exhibits in the underlying trial. I actually was somewhat surprised that the board would have taken the position that our layoffs were not the same or similar in kind and substance to what had occurred in the past. Layoffs are not something that like in Raytheon, where they're every year facing a healthcare implementation and they're making changes to that healthcare plan every year. Layoffs are very circumstantial. And that's why I think we need to look at circumstance, decline in work, and what Wendt's action was. And even the testimony of our witnesses in the underlying trial specifically noted, and the board, and certainly the general counsel, never put in a single bit of evidence as to anything different that Wendt did when faced with a downturn in work. There's a dearth of evidence on that.
Do my colleagues have further questions for Ms. Schroeder?
I do not.
Oh.
All right. Thank you, Ms. Schroeder. We'll give you a brief amount of time for rebuttal.
Thank you, Your Honor.
Ms. Rajapaksa.
Thank you.
I'm sorry, you just butchered your name. And I'm guessing I'm not the first person who ever did that.
No, you're not. And you actually did quite well. May it please the court. My name is Meelakshmi Rajapaksa. I'm counsel for the National Labor Relations Board. This case involves the board's findings that Wendt committed numerous unfair labor practices in the first year after its employees designated a labor union as their collective bargaining representative. Most of the unfair labor practices at this point are uncontested, and the board, of course, seeks summary enforcement of its order as it corresponds to the uncontested unfair labor practices. With regard to the contested findings, I do want to focus on the unilateral changes that were the subject of Ms. Schroeder's discussion with the court today. In terms of the past practice defense, Judge Pillard, I do think that you correctly identified the problem that Wendt faces, which is that in Raytheon and Mike Sells, the board didn't fundamentally change the quantum of evidence, so to speak, that the employer has to put on in order to establish a past practice in the first place. So the company at minimum has to show that the overall frequency and number of past events amount to a past practice. And if you look at the unilateral removal of work, the company certainly did not clear that bar.
When you read the earlier decisions, they seem to talk about, this dynamic status quo, the idea that there are going to be things that are going to have an impact on terms and conditions of work, like changes in the amount of premiums and the benefits that one gets under the same status quo health plan. That makes sense to me. This notion that we're going to unplug from that and just say overall frequency and number of events could be a past practice. Is there any way you can help us understand that this isn't just some random number cutoff or frequency eyeballing by the board?
Well, the board is bringing its.
I'm a little surprised that something like a layoff, which, as Ms. Schroeder explains, can be very important prerogative for a business, but also is not something that is sort of a dynamic status quo. It's very circumstantial. Like, how could that ever be part of this this doctrine of past practice?
So the board confronted this very type of issue in Mike Sells, and Mike Sells involved an irregular practice, sort of like the layoff that we're confronting in this case, or the practice of layoffs, the so-called practice. In Mike Sells, the issue was some subcontracting decisions, which don't occur annually or at set intervals. But the board said that in order to honor employees' right to bargain collectively about changes to the status quo, there has to be some minimal showing that the number or frequency of past events amounts to a practice that employees could have expected. So in the Mike cells, the facts were that there were 51 subcontracting decisions that were made over a period of 17 years. And even though the decisions were not regular, even though in some years there may not have been decisions made, overall, looking at the prolonged period, there were a sufficient number of events. The board took the same approach in this case. It considered a similar 17-year period and how many layoffs took place in that 17-year period. And the Raytheon decision enters into the analysis because the issue is not just number and frequency, it's also comparable events. Under Raytheon, the board was very clear that the past events cannot materially vary in degree or kind from the event at issue. So the board, it was entirely fair for the board to look closely at the particular layoffs that the company is citing.
The thing I'm perplexed about is that the company is arguing that it has been their consistent practice over this period to lay off employees due to a lack of work. Well, you can't demand a certain number because part of the equation is a situation involving lack of work. And what they said was when there was a lack of work, they routinely reduced their workforce. And that was not refuted by the board. And so within the time period looked at, I don't know what more you could expect the company to do. And they also subsequently pointed to the handbook. I'm not sure we can even consider that, but in any event, they said when there has been a situation in which there has been a lack of work, we have laid employees off. And I think the case that you're citing, Mike Sell, I wasn't persuaded that's in any way inconsistent with what we're talking about. We're talking about a situation here when there is a lack of work, we lay people off, and it's not an insignificant number, but it's consistent. The company's position is consistent, and there's nothing to indicate there are circumstances when they did other than what they claim when there was a lack of work.
Right. The issue for the board is there has to be some. This occurrence that you're talking about, Judge Edwards, is relatively infrequent, right? The occurrence of temporary layoffs of shop employees happened twice in the past. And so, yes, 100%
No, it
of
was
the
more
time.
than twice.
No, the
2001, 2, 3, 9, 15.
Well, 2002
well.
and 2003 are admittedly the layoffs of a handful of employees at most. What we are talking about in this case is a layoff of 1/3 of the shop, or 10
Why does it matter? Well, the number of employees who are going to be laid off is going to be affected by the economic circumstance. So I don't know what you're telling me. You say there were only a few in 2001. So what? That was all that was required because of the nature of the economic circumstance. You wouldn't lay off more than was necessary in any of the years when you had to lay off. But what they are saying is whenever there was a change in our economic situation, we would lay off employees, whether it was a handful or a whole department. It depends on the economic circumstance.
Right. So there are two sort of prongs to the past practice analysis. One is the nature of the past actions, the similarity of degree and kind. The other prong is frequency or number. So I think we're kind of mixing two different things. The 2002 and 2003, and to the extent you want to think about it, 2005 unfair labor, past practices were not similar in degree and kind to the layoff, because those involved at most, 1, 2, 3 employees. This particular layoff.
Again, I'm repeating myself. I don't know why that matters.
It matters because under the law, the past actions have to be comparable. They have to be
because
comparable.
The duty to bargain obligation wouldn't allow them whether it's 1, 2, or 3 doesn't matter. The duty to bargain would be there if they didn't have the past practice. Whether it's 1, 2, 3, or 103, they would have to bargain.
Well, the
And
issue
what
is
they're
with
saying
those,
is, in the past, whether it's 1, 2, or 3, or 103, we have always laid off as necessary.
those are
It seems to me perfectly comparable. And the number of employees affected depends upon the economic circumstance that the company has faced. And there's nothing to indicate the company is playing games there. They were honestly pointing to situations where there was an economic downturn and they reduced an appropriate number. They're saying, and here there was an economic downturn, not contested, and we reduced an appropriate number. That's the practice that we're looking at. It would make no sense to say you have to show that there is a practice of how many did they reduce here? 20? You'd have to show 18 times in which they reduced 20 employees in order for there to be a binding past practice. That's a ludicrous rule. That makes no sense.
well, Judge Edwards, I would respectfully say that you have to look at the policy behind this requirement of similarity in degree and kind. The
Duty
purpose,
to bargain.
well, it is the duty of bargain, but it's also that the question is, have the past actions forecasted essentially for the union and employees
Right.
that this kind of action is going to happen. It's a recurring sort of thing.
No. When you say recurring, you have to be careful, I think, when you say recurring. Recurring has to be read with reference to the condition, that is, economic downturn. So it will recur as there are economic downturns. You can't demand the company that the company show that there were economic downturns every year in order for the practice to be binding.
And the board didn't do that. The board didn't impose that
So
requirement.
it seems to me there are an awful lot of occasions here where the company has said, and the board's kind of dismissive. I think in one they said, one involved both shop employees and non-shop employees.
That was
So
2009. Right.
I read that and I laughed. I mean, why is that relevant that it involves shop and non-shop employees? The point is they're saying it involves shop employees, which is what we did here. We have and so the board dismisses one of their examples, and there was another ludicrous dismissal too. All situations in which the company is saying there was an economic downturn and we have consistently let people go during economic downturns. There's no instance in which we have not. We're not doing anything different here. And the number of employees let go depends upon the nature of the downturn. That seems totally reasonable.
The board looked at sort of whether these past actions would have given the union and employees notice that, this is what the employer does. This is how it would handle a temporary layoff.
Right.
And the problem is—
Wait. How it would handle a temporary layoff or would have a temporary layoff?
That it would have a temporary layoff and what would happen in the temporary layoff.
Wait, there was no union before.
Right, but
so you can't bring that into the equation. So there was no obligation to bargain. So the employees don't have an expectation of a duty to bargain because there was no union. So that's not in the equation.
The issue is, what was the status quo, right? What is the status quo as to these temporary layoffs? And you have to look at the two temporary layoffs to understand, so that the employees and the union could understand, this is what is going to happen. This is what the employer will do. There's nothing to bargain about. We already know. And in this situation, all the board is saying is the employees in the union could not have known from two prior instances.
And what are you saying they could not have known? They could not have known that the employer would reduce the staff in the event of an economic downturn?
That it would
think these employees had reason to know that?
That would have a mass layoff of 1/3 of the bargaining unit?
Mass or laying off employees appropriate in number to the economic situation before the company. That's the way I would define the practice.
Well, the board defined the relevant action that it was looking at as a temporary layoff that affected a sizable group of employees. Here it was 10. So there were other sizable layoffs, but there were 3. One of them was a permanent layoff.
Why does that matter that it's permanent? They are reducing the labor force with reference to an economic downturn. And what the employees know, if there's an economic downturn, they're going to reduce the workforce maybe permanent, maybe temporary, but they are going to reduce the workforce. So that's 3 we have. Now, how are you dismissing the other 2?
Well, I'm not dismissing them. I'm just saying they're not sufficient.
Right.
Two temporary layoffs are not sufficient.
No, they're
in a period of
5.
17 years.
5.
The other layoffs are affected they were essentially one-off decisions to lay off 1, 2, maybe 3 employees. They are not comparable to the decision to lay off 10 bargaining unit employees.
And I guess it's a matter of definition.
Ms. Rajapaksa, I'm curious about the implications of this in the sense that so the point of the past practice is that it excuses a duty to consult with the union that would otherwise apply. And in Mike Sells, the board says, of course, the union can request to bargain over whether to change the practice itself. So had the employees in this case, or the union in this case, I guess one question is, how do they know that this would be treated as a past practice and a defense before the board? But if they want to going forward, they can ask, say like, no, we think when the employer is laying people off in response to economic downturns, that it should come and talk to us about it. And we should, that's important to our terms and conditions. So it is not, I mean, I'm just having a little trouble processing that comment in the end of Mike Sells and how it works, because as I understand from Raytheon, the point of this past practice doctrine is that it is not a change in working conditions that is subject to bargaining if something is a past practice, but it can nonetheless be put on the table by the union.
Right. So the union can bargain over changes to the status quo. So there is, I think all that Mike Sells was saying, it was clarifying really, because there was some confusing language in Raytheon on this point. The employer has a right to maintain the status quo as to its past practices. However, if the union requests bargaining about a past practice and proposes, for example, changes to that practice, there is a duty to bargain over the issue going forward. So,
but if they don't change the past practice, if the employer keeps the past practice consistent, that does not create an opportunity for example, newly unionized workforce to say, hey, we see that as a big deal. We want to bargain over that.
No, they can request bargaining over that.
Yeah. They can request it immediately. As soon as the company announces they're going to lay off, the union can come in and say, we want to bargain about it. And the company would have to bargain about it.
And they just are bargaining over the past, whether the past practice should continue. It seems like,
yes.
I guess I'm having a little trouble because it feels like a very formalistic distinction to say you can bargain over whether the past practice continues, but you can't bargain directly over layoffs that the employer characterizes as consistent with its past practice.
Well, you can, I mean, the parties can bargain over both the implementation of the current decision to lay off as well as the issue going forward. But the point of the Mike Sells case, for example, is that the employer can go ahead and unilaterally implement.
Unilateral, that's they don't have to reach impasse. You don't have to bargain the impasse, but the union can still come in and say, we understand you're following what you think is a past practice. We want to bargain about it. The company would have to bargain about it. But the company is saying we did not have to reach an impasse over something that we have consistently done, even though there's now a union here. And I don't see why, I don't see how you get over their claim that there was a consistent practice of we will let people go in the event of an economic downturn. I just don't see it. The distinctions you're raising seem really very strange to me. There were only several people, one occasions it was permanent and not temporary. They're distinctions without meaning.
Well, the requirement of similarity between, various past events and the current event is in CATS, for example.
There's no question about it. But we're talking past each other, so I will stop. But what I am saying is similarity is measured by reference to how you define what we're talking about. And the company says what we're talking about is our right to let people go when there's an economic downturn. And they would say, so is this similar? It is similar because we let people go during an economic downturn. You're trying to nitpick it to the point and say, no, no, no. We have to count the number of employees. We have to count which days they were let go. We have to count whether they were men or women. We have to look at the weather. That's not what the cat's rule is.
Well, I respectfully have to disagree with you, Your Honor,
disagree.
because the board's decision is written as it is. However,
Okay.
I will say, to the extent that the court disagrees with the board's framing of the past practice, the board would appreciate a remand to consider whether 5 past instances is enough to amount to a past practice that would have sheltered the unilateral action from bargaining. So I see that I've.
Other further questions
Nope.
for Ms. Rajapaksa?
No.
Ms. Schroeder, we will give you 2 minutes for rebuttal.
Thank you, Your Honor. It's very clear from the questions and the responses, exactly what the issue is in this case, and I don't want to belabor it too much. I just think it's very easy in the business world for the board to sit in hindsight and then to nitpick, as Your Honor, Judge Edwards points out. Was it 5 people? Was it 4 people? Was it for 3 days? Was it permanent? Were salaried people let go at the same time as unit people? There would never be any past practice because everything is dependent upon the circumstance. And so I'm asking that we really look at the Mike Sells case and say, what we're concerned with here is, what is the circumstance? What is the employer's response? And that is the consistency that we need to look for. And I submit to this court that my client did exactly what it had done a good number of times in the past when faced with this circumstance. And it would have been very clear to anyone, because there was no other evidence in the record to the contrary, that this is what was going to happen. Thank you very much.
Thank you both. The case is taken under advisement.
Case number 20-7077, Joshua Atchley et al. Appellants versus Astrazeneca UK Limited et al. Mr. Branson for the appellants, Mr. Shanmugam for the appellees.
Good afternoon, counsel. Mr. Branson, you may proceed when you are ready.
Thank you, Judge Pillard. May it please the court. The defendants bribed Jaish al-Mahdi terrorists both in cash and in kind, and they knew their bribes were funding terrorist attacks in Iraq. That is more than enough to state a claim for primary and secondary liability under the Anti-Terrorism Act. In holding otherwise, the district court misapplied basic Rule 12 standards by ignoring or recasting large portions of the complaint. The defendants now continue the same theme on appeal, repeatedly asserting their version of the facts. But this is a motion to dismiss, and once our very detailed allegations are accepted as true, none of the district court's rulings can stand. The district court erred on 4 issues I'm hoping to cover this morning: proximate cause, aiding, abetting, Hezbollah, and personal jurisdiction. Now, the first 2 are quite similar, but aiding, abetting is actually even easier than proximate cause because the statute contains no direct link or other causation requirement for secondary liability. And indeed, a recent trilogy of appellate decisions from the 2nd and 9th circuits, Kaplan, Honickman, and Gonzalez, have reversed district courts for misconstruing aiding, abetting principles in much the same way that Judge Leon did here.
Are you saying that for aiding and abetting liability, the plaintiff doesn't have to prove that the principal who the defendant was aiding and abetting was a proximate cause of the injuries?
No, Judge Wilkins, I'm not saying that. I should have been more precise in my language. When I said there's no causation requirement, I meant that there's no causation requirement that the defendants cause plaintiff's injury. But you're absolutely correct. For secondary liability here, Jay Shalmati must have proximately caused plaintiff's injuries, and I don't view that element as being in dispute at this stage.
Right. All they have to do is show that they were provided substantial assistance. So you're distinguishing substantial assistance from the kind of substantial factor that counts for direct liability.
That's correct, Judge Pillard. To be clear, we've pleaded both. And I think that, as we explained in our brief, Judge Leon made a very similar error in disposing of the proximate cause issue and the aiding abetting issue, in that he misconstrued our allegations about the Ministry of Health. But I do agree, Judge Pillard, that substantial assistance, and you can just see this from the court's Halberstam opinion. I don't think most people would say Linda Hamilton proximately caused the murder, and yet she was held liable for it. And so I do think the analysis is even easier for aiding abetting, and I would submit that that is the most straightforward path to reversal here. That said, oh, I'm sorry, Judge Pillard, you can ask a question. Oh.
You're getting there.
So to move to proximate cause, as I said, I think that Judge Leon made a fundamental error in disposing of both our primary and secondary liability claims. And I really just have 3 points about that. First is the ministry was a known terrorist front, not an independent intermediary. It was, in the words of U.S. Embassy Baghdad, quote, openly under the control of the Mahdi army of Muqtada al-Sadr. That's paragraph 169 of the complaint. Once that allegation is accepted as true, this decision should be reversed. Terrorist-controlled intermediaries do not defeat causation, and they certainly do not preclude aiding abetting liability.
So you're making a very important distinction between a state sponsor of terrorism and a terrorist-controlled entity, even though in nomenclature they may sound similar. A state sponsor of terrorism is a government, a nation state that harbors in some way terrorists or doesn't go after them, whereas here you're saying no, that Judge Leon made a false equation between a governmental agency and a nation state.
Judge Pillard, that's absolutely correct, and I think this court's Owens 4 decision makes that plain, in that nobody claimed that Al-Qaeda was running the government of Sudan. Sudan was not an instrument of Al-Qaeda. Did it support Al-Qaeda? It absolutely did. But I think the point of Owens 4 was that because Sudan was an independent intermediary, and again, that was this court's words, it severed the link between the bank, and Al-Qaeda. And we have pleaded the opposite of that. We've pleaded that the Ministry of Health was not an independent intermediary at all. I would also want to emphasize another key distinction with Owens 4 on that front, which is BNP's money never got to Al-Qaeda. And that's true of every intermediary case the defendants cite. Owens 4, Rothstein, Kemper, Brill, Siegel, all of them. The bank's money doesn't get to the terrorist group. It stops with the intermediary. Here, Judge Leon himself recognized that we have pleaded exactly what was missing in Owens 4, in that the defendants' free goods payments financed Jaish al-Mahdi, not any legitimate Iraqi health program. And that's most apparent at JA 835, where in Judge Leon's words, defendants were aware that their goods, quote, would be used by Jaish al-Mahdi to support terrorist attacks, close quote. That is the sort of substantial connection to terrorism that Owens 4 held would be sufficient. The plaintiffs in Owens 4 did not meet that test. We do. The third point is the cash bribes. And I want to pause here because these are very important. The defendants paid individual cash bribes to the terrorist operatives who were at the ministry. And no matter what this court thinks about the status of the ministry as a juridical institution, the point of a bribe is that it goes to the individual, not the institution. That's what makes it a bribe. And so I don't think anybody is disputing that if those bribes were paid, it would violate the statute. All that's disputed is whether we've properly pleaded them. And as we've explained in our papers, are many pages of allegations about these bribes more than satisfy our pleading burden under Twombly and Iqbal.
I'm trying to understand how you think that the scope of the liability works. Let's suppose we send your case back, and let's suppose that that the fact finder does not believe that you've proven the bribes, and all that the fact finder finds is that that the defendants did business with Jay Shalmad or with the health ministry. Because with the health ministry, I'll say, is that sufficient in your view for liability? Because if they did business, even without paying bribes or providing, extra goods that could be sold on the illegal market, that's material support because of the I guess the unity of between Jay Shalmadi and the Ministry of Health.
Yes, Judge Wilkins, we do think that. We've alleged that at paragraph 179 of the complaint. We don't think we need to prove the bribes in this case. I think you can see that most clearly. The analogy would be the Ninth Circuit's Gonzalez case, where Google didn't do anything special or illegal to support ISIS. It just had a commercial business relationship, and the Ninth Circuit reversed the dismissal of aiding and abetting claims. So yes, Judge Wilkins, the answer is yes. That said, I think this case involves quite a lot more than that, and the bribes are our lead theory, I would say. And the reason is, the Special Inspector General for Iraq Reconstruction called.
So if you're right, then the U.S. government provided substantial assistance under your reading of the statute, right?
I don't think so, Judge Wilkins. I don't think the U.S. government did business with the ministry in the way that you're positing. Certainly, the U.S. government built infrastructure projects. It tried its best to clean up the ministry. It attempted to wrest control of the ministry back from Jay Shalmadi through things like the arrest of Hakam Zamali, who was the deputy health minister, who, in General Petraeus's words, had, quote, effectively hijacked the ministry. General Odierno ordered a military operation in June 2007 called Operation Black Crescent that was attempting to address this very problem. And that's at JA 794. So no, I know, Judge Wilkins, that the defendants say that a lot in their brief. There's no question, but there's no evidence of that. And more importantly, we don't allege anything that would support that inference in our complaint. If you look at paragraphs 76 and 113 of the complaint, we allege that the U.S. government did not support the Jay Shalmadi controlled ministry, did things like build hospitals while trying to clean the ministry up. And this goes to a very important point that even Judge Leon accepted at JA 824, where he acknowledged that taking our allegations as true, what the defendants did was counterproductive to the U.S. mission to improve the Iraqi health system. So this notion that the defendants are trying to argue on a motion to dismiss that they are hand in glove with the U.S. government is just not true, and it's certainly not alleged in the complaint.
So on the direct liability, the district court only reached proximate cause and actually only reached the independent intermediary block to a showing of proximate cause, and didn't actually even go further and consider even if there is an independent intermediary, as we know, there can nonetheless be liability if there's a sufficiently, I'm going to get the words wrong, but if there's sufficiently substantial showing of aid nonetheless. But the district court did not go on to look at the reasonable foreseeability aspect of the probable cause determination, nor did it consider the act of international terrorism aspect. And in the act of international terrorism, am I correct that here the allegations are that the acts of international terrorism are material support for terrorists and terrorist funding under 2339A and C?
That's correct.
And am I correct that the statute, that 2333A requires such an act, but that additionally, the defendant have violated such law in a manner that appears to be intended to intimidate or coerce a civilian or influence policy of a government or that's a overlay on the incorporated act of terrorism. Is that correct?
That's correct.
Okay. And is there precedent that recognizes 2339A and 2339C as qualifying acts of international terrorism?
Yes, Judge Pillard, the Boehm case from the Seventh Circuit involved 2339A.
Yeah.
So there is precedent for that. There are some district court cases that have recognized 2339C. I don't believe that particular issue has made its way to an appellate court.
And in terms of the appears to be intended to, that is a legal question. There is a complaint before us. Are you asking us to reach that? Are you asking us to remand if we were to agree with you? I'm just trying to get the scope of your position. If we were to agree with you that the dismissal based on a lack of probable cause might need further thought, should we reach or should we not reach the act of international terrorism?
I'm hesitant to give the court advice about what it wants to reach. I certainly don't think it has to reach the question. This was not, because of the posture of how we briefed this, I would say the briefing is rather sparse before this court because it was an alternative argument. I think it would be a sensible course to remand. Of course, this court does have discretion to decide it if it wants to, but I suppose if you were to ask my views, it would be to remand because Judge Leon did not reach this question and it has not been, I would say, briefed as thoroughly as the other issues in the case. That said, I do think the Boehm case that we cited provides some very good precedent for our theory, which is that courts typically presume that people intend the natural consequences of their actions.
True enough, but when you're giving directly to, was it Holy Land Foundation, that looks a little bit more like the US donors possibly being on board with the mission of the ultimate terrorist group than giving then contracting for medical goods with even a defunct and hollowed out Ministry of Health in Iraq.
Well, I disagree, Judge Pillard. I don't think that inference you just drew was in the opinion. If you read the district court opinion in the Boehm case, which I would encourage you to do, this was not cash given directly to Hamas. The defendants claim that it was, but that's not what happened. It went to a variety of charities that did legitimate charitable things like social welfare services.
Was Holy Land Foundation, I guess, is in the caption.
That's right. Holy Land Foundation was the defendant, but if you read the district court case, they were not giving money directly to Hamas. They were funneling it through, I think, a list of about 10 charities. And not all of them were even controlled by Hamas. Some of them just were independently aligned with Hamas. So I would say that our allegations are stronger than the ones in Boehm. And the reason that my friends' cases are off point is they've cited cases like Kemper and Brill where there was no proximate causation. So this theory that we're articulating didn't work for those plaintiffs because the natural consequence of their actions did not include terrorism. So if this court were to reach it, I think the comparison to Boehm is good. I would also encourage the court to look at Judge Lamberth's opinion in the Woltz versus Bank of China case, a very, I would say, somewhat comparable fact pattern where the defendant made all the same arguments that we're a reputable bank. We could never intend to cause terrorism. And Judge Lamberth applied the principles I just articulated and denied the motion to dismiss. And I think the same result should obtain here.
On your aiding and abetting, I'm sure you're getting there. I wonder if you could talk to us about designated terrorist organization Hezbollah's role in committing, planning, or
authorizing, Judge Pillard.
Authorizing, thank you.
I think it's an excellent question. That's exactly where I was going next. And I think the important point was built into your question, which is that Congress did not limit secondary liability to terrorist acts committed by a designated FTO. Instead, it extended liability to acts that are planned and authorized by an FTO. And the reason was to cover attacks committed by a terrorist proxy group of a designated organization, like Jaish al-Mahdi was for Hezbollah. Jaish al-Mahdi was an instrument through which Hezbollah orchestrated terrorist attacks against Americans in Iraq. And on that issue, I would encourage the court to read the amicus brief by the commanders, signed by General George Casey and many of the other top generals from Operation Iraqi Freedom, explaining how deeply Hezbollah was involved in Jaish al-Mahdi's terrorist operations and why the district court's logic misapprehends the way these groups work in practice. So I don't view Hezbollah's role as really being disputed here. I think the only question is whether it was sufficiently linked to each individual attack.
Right, the defendants really push you on, it's not enough to train, it's not enough to inspire, that's just very general. And the way they read the statute, and it's a natural enough reading, that planning and authorizing is a much more event-specific verb.
Well, that may be true, Judge Pillard, but we have tied the training and the planning and the provision of munitions to our individual attacks. I think that's really not even contested. The easiest place to see this is for explosively formed penetrators at paragraphs 395 and 96 of the complaint, where this was a Hezbollah signature weapon, and Hezbollah was involved in every single penetrator attack in Iraq. And so, Judge Pillard, I suppose one reading of the statute that I guess I understand my colleagues to be advocating for is that you have to plead that a Hezbollah individual operative showed up to the scene, the street corner where the attack took place, and have to point, hey, Jaish al-Mahdi, plant this IED here, and I want you to blow up that Humvee. And anything less than that is not planning or authorizing. I think that's textually unfounded, as we've explained in our brief. Planning and authorizing does not require control of all of the details. But I think it's also inconsistent with the way these groups work. And again, I thought the amicus brief from the commanders was quite compelling on this, that's not how Hezbollah orchestrates attacks. It doesn't send Ali Musa Dakduk, its commander in Iraq, to the street corner in Sadr City and plant an individual IED. It orchestrates the infrastructure through which Jaish al-Mahdi then commits these attacks. And for every attack alleged in the complaint, we have alleged a tactical and a geographic nexus tying Hezbollah to the individual attack. And on a motion to dismiss, that's
but you're kind of doing this backwards. You're saying that we have to interpret the statute so that it comports with how terrorist organizations work. No, we have to interpret the statute and we see whether the way that you have alleged that this works fits within the statute, right?
That's true enough, Judge Wilkins, but I think we've done that. I mean, my colleagues, it's not like they define the word planning and authorizing that excludes the theory I've articulated. A person, just the ordinary meaning of the word planned, you plan an attack if you, for example, the example we gave in our opening brief, if a Hezbollah operative trains a room full of Jaish al-Mahdi fighters how to use 107 millimeter rockets against Americans in Iraq, and does so with the specific intent to cause Jaish al-Mahdi then to commit those attacks using those rockets. Hezbollah has planned those attacks, whether or not the Hezbollah operative then shows up to the street corner and says, now I want you to employ what I taught you and go blow up this particular target. Sorry, Judge Wilkins.
So if I, train my law clerks on how to write briefs and how to make arguments, am I planning their future briefs and arguments?
I think arguably you are, Judge Wilkins, but this case is even, I think, easier than that because there's specific intent. And that is a critical facet of our allegations. That Hezbollah didn't just train Jaish al-Mahdi because it wanted Jaish al-Mahdi just to be good terrorists in the abstract. It did so for the particular purpose of orchestrating terrorist attacks against Americans in Iraq.
The statute doesn't require that, or are you reading plan and authorize? I mean, I guess authorize does, but what about plan? Are you reading plan in a manner that would require some proof of intent on the part of Hezbollah?
I think I am, Judge Pillard. I think when you plan an act, you have to have intent for the act to take place. And the fact, our allegations that Hezbollah wanted these attacks to take place, that's not disputed here, and I'm not anticipating any difficulty proving that if the case were to be remanded. But I do think it distinguishes it from a lot of the hypotheticals you can think of, where if all Hezbollah had done was given a small cash donation to Jaish al-Mahdi and said, I want you to have this because we support Muqtada al-Sadr's mission of allegedly providing care to Iraqi Shia, that wouldn't be enough. But I think that the tight nexus between what Hezbollah has done and each attack here is really distinguishes it from the other hypotheticals that have been given. And in the commander's brief, they have cited district court cases from judges in this district that have made evidentiary findings about Hezbollah's role in an individual attack based on little more than the weapon type and the geography in which it was used. So, I actually think that we're going to have experts and we'll be able to prove that even without any other evidence beyond what's alleged in the complaint, if there was an EFP, that's the acronym for the penetrators, that went off in Sadr City, Hezbollah was involved in that. And at a motion to dismiss to require us to plead more, Judge Wilkins, to your point about does the reality of terrorism affect this statute? I think it does, because Congress stated that its purpose in enacting the Justice Against Sponsors of Terrorism Act was to provide the broadest possible basis to afford relief against companies that finance terrorists directly or indirectly. And under their view of the statute, I think this cramped FTO requirement that they're adopting would gut Congress's purpose, and that absolutely is something that this court should consider.
So just to review on the aiding and abetting, the state of mind requirement is different from the requirement for direct liability. In your view, it's only knowingly providing substantial assistance?
I think the Second Circuit, Judge Pillard, has actually cleaned this up quite a bit in the Kaplan and the Honickman cases. For aiding and abetting liability, I think the state of mind requirement is general awareness. And as the Kaplan case explained, that's actually less than fully focused knowledge. Linda Hamilton did not even know about the murder for which she was held liable. She didn't even know that Bernard Welch was committing burglaries. So it's general awareness of the defendant's role in an illegal activity from which terrorism was a foreseeable risk. That is the standard the Second Circuit has adopted, and I think it's correct. Now, you're correct that the state of mind factor for substantial assistance, Judge Pillard, I think the degree of knowledge is relevant to that inquiry. But what Judge Leon held was actually the standard is specific intent, that the defendant has to be one in spirit with the terrorists, and that's just not right. That's not anywhere in the statute. It's inconsistent with aiding and abetting doctrine, and the Second and the Ninth Circuits have now rejected it. And the Ninth Circuit in Gonzalez actually reversed the district court case that Judge Leon cited for that requirement. So I think degree of knowledge is one of the factors, and I don't think it's seriously contested here. Judge Leon acknowledged that these defendants knew. But it's certainly not specific intent, and I think it's very, very important for the court to reject that standard.
You have these two theories, two separate counts on aiding and abetting. One is the RICO count, and the other is the more direct authorization. If we were to believe that Judge Leon erred with respect to dismissing one, do we need to reach the other? Do we need to reach both?
I think you do, Judge Pillard, because they're separate counts and Judge Leon dismissed both. So I do think you need to reach the RICO count. And if I can address that just briefly, it all depends on what does the word act mean. Can the word act encompass a multi-year terrorist campaign? I think Judge Wald's opinion in Halberstam answers that question. The court there defined the act assisted, that is the court's words, as the multi-year burglary campaign. We know Congress wanted Halberstam to provide the legal framework for how aiding and abetting liability should function. And so, and that's an argument I think you'll find conspicuously missing from the district court opinion and from my friend's briefs.
Well, why do you even need RICO? I mean, in a way, it seems like it's almost a factual question. Like either, as you say, I mean, there's no RICO claim in Halberstam.
Right.
Why isn't it just, either the individual acts or a whole campaign in more common sense problems? Somehow, I mean, RICO is a hornet's nest. That's technical terminology. And so I just wonder, is RICO as such doing any work for you?
Well, the reason we cited RICO is because, Judge Pillard, as you noted, I think in your questions earlier, there needs to be a predicate criminal violation of U.S. criminal law for the definition of the act of international terrorism. And so we defined RICO, and I realized RICO can scare some people off. There have been a lot of bad RICO cases that have been brought in history. But we're not claiming the defendants violated civil RICO. What we're claiming is that Muqtada al-Sadr's terrorist enterprise was a RICO violation. And that is what the defendants aided under count 2. And in terms of whether RICO's predicates have been met, that issue is not on appeal before this court. I think you treat that as true. And so really the only question is, can a multi-year campaign be an act in the context of this statute? And we've explained why in our brief we think it can, but again, I think Halberstam provides the answer. Judge Pillard, I think your question is a clever one, and I think you can also incorporate this concept into count 1 for the reasons you described. That this is a factual question, and you'll find some support for that in the Second Circuit's Kaplan decision and in the Ninth Circuit's Gonzalez decision, which both took care to define the act assisted, the principal violation, not as the individual bomb going off that injured the plaintiffs, but the broader terrorist enterprise perpetrated by the person that the defendants aided. And so I think those cases also provide some ammunition, Judge Pillard, to write the opinion in the way you were just suggesting, if you were inclined to go down that route. I see.
If act of terrorism is.
Sorry, Judge Wilkins.
If act of terrorism is defined that broadly, and planned is defined broadly to include basically training, which is the way that it appears that you're arguing this, then it would appear that even in circumstances where kind of the FTO is kind of in the background, maybe years in the past, involved in training someone who goes out and commits an act of terrorism. And even if that's not really very apparent or publicly known, there's going to be aiding and abetting liability.
Well, Judge Wilkins, I think there's got to be some sort of a nexus between the training and the attack. So, for example, we don't plead any of these claims, but let's say there was a suicide bombing in Iraq that Jaish al-Mahdi conducted to blow up an American. Hezbollah training them how to use penetrators doesn't have a nexus to that attack. So I don't think that would constitute planning. But the other point that I think should address your concern, Judge Wilkins, is go back to my specific intent point, that the FTO has to be doing it for the purpose of causing the type of terrorist attacks at issue. And I think that's been pleaded here in spades. And Judge Wilkins, to your question about whether it's publicly known or not, the FTO's role, that's not an element of the statute. There's no suggestion that a defendant has to be aware of the FTO's role. It's just they have to be aware that they're assisting a person, a terrorist group that's committing acts of international terrorism. And to give you, Judge Wilkins, an example of something that's outside the line, look at the only case that my colleagues and Judge Leon cited, the Sixth Circuit case from the Crosby versus Twitter case. That was a lone wolf shooter that shot up a nightclub in Orlando, Florida, the Pulse nightclub. Never had any contact with ISIS, wasn't part of ISIS. ISIS didn't train him, didn't give him anything, didn't authorize the attack, didn't say anything to legitimize it. That's an example of something that our theory of the statute would still rule out. But I would encourage the court not to treat the planning and authorizing element as though Congress intended that to substantially circumscribe the scope of the statute. There's no textual or structural evidence that that's the case. And if you look at Congress's declaration of purpose in the Justice Against Sponsors of Terrorism Act, there's no reference to foreign terrorist organizations, and the Congress has declared that its purpose is for this to sweep broadly. So, the fact that this might cover lots of terrorist attacks, that's a feature, not a bug of our interpretation. Because remember, a defendant is only liable if they aid and abet the terrorist group, and if they're generally aware that by doing so, they're playing a role in illegal activity from which terrorism is a foreseeable risk.
I missed what you just said. You said there's nothing in the JASTA reports or whatever referring to foreign terrorist organizations, but in the text, there's a requirement that the act be committed, planned, or authorized by a foreign terrorist organization. And it's striking that even though aiding and abetting is typically easier to meet, in this statute, the aiding and abetting provision has this requirement that's not in the direct liability part. So it does feel like it is a narrowing or boundary setting provision.
Well, there's no question it's boundary setting, and I'm not suggesting that the court should treat this as not an element. It is, but I was attempting to address Judge Wilkinson's specific point, which is when you're interpreting the words planning and authorizing, which I submit are very broad words, the court should not be thinking about this from the perspective of we have to really narrow this to a very limited set of attacks. That is not, there's no evidence that that's what Congress wanted this limitation to do. I would submit that what Congress wanted this limitation to do would be to rule out the lone wolf shooter type situation, the Crosby case that the defendants cite. And so you're absolutely right, Judge Pillard. I'm not suggesting read the element out of the statute. It's an element, we have to meet it. But these words on their own, it's not as though my friends on the other side or Judge Leon defined the word plan and authorize in a way that limit out our attacks. I mean, we've defined the words. We basically all agree on what they mean. The question is just how do you apply them to terrorism? And I would suggest, in light of the statute's purpose, that if there's any question about that, the court should not be looking to limit this to attacks that actually look like they're committed by a foreign terrorist organization, because that would be atextual, and I think that would do violence to Congress's purpose, as again, not to beat a dead horse, but as I think very persuasively explained in the commander's amicus brief.
I'm sorry, I know we've kept you a long time, but I'd appreciate it if you could address personal jurisdiction over the foreign defendants.
Thank you, Judge Pillard. The foreign defendants purposely availed themselves of the United States by sourcing U.S. drugs, by working with their U.S. affiliates, by procuring U.S. documentation, and by certifying the U.S. origin to their terrorist counterparties. I think there's no question in this posture that constitutes meaningful jurisdictional contacts. The question before this court is whether they are sufficiently suit-related to support specific jurisdiction. And after the Supreme Court's decision in Ford this year, I think that case confirms that test has been met. We know right out of the gate that Judge Leon applied the wrong legal standard. This is at JA 819, where he said that for contacts to be suit-related, the contacts need to be such that would expose the defendants to liability under the Anti-Terrorism Act. We know that's not correct now after Ford. A contact does not need to be tortious. It does not even need to be causally related to the claims in order to qualify. I think the question under Ford is whether the contacts demonstrate a meaningful affiliation between the forum and the controversy. And I think certainly in this procedural posture, taking our allegations as true, we have more than satisfied that burden. And I'll just make 3 points on that if I could. The first is that the US sourcing was not a coincidence. I know my friends in their brief repeatedly characterize it as happenstance or kind of accidental. That's not what we allege. The complaint alleges in detail for every defendant that the sourcing was a deliberate choice designed to be able to obtain these contracts in the first place and to magnify the value of the bribes being delivered to Jaish al-Mahdi. So that's the first point. The second point is that they were working with their US affiliates. The way these transactions worked is that it's not as though the foreign defendants in isolation handle the contract with no interaction with their US affiliates. We've alleged for every defendant that there were these what we call cross-functional teams where the US manufacturer and the foreign supplier work in concert to fulfill these orders. And that is very much suit-related conduct. And then the third point is something—
Was that alleged for all of the manufacturer defendants as opposed to the supplier defendants?
Yes, Judge Wilkins, it was. So the manufacturer defendants, just to be clear, those are all American companies. So the manufacturer defendants there's not a jurisdictional question pending before this court, I suppose, other than the pendant jurisdiction question for state law that I think my friends and I agree on. But the manufacturer defendants are US companies, and they are not raising the personal jurisdiction challenge. So we're only talking about supplier defendants. And for the supplier defendants, yes, the answer is yes. We've alleged it for every defendant that they worked with their US affiliates. And I think, Judge Wilkins, your question is a good one because it brings me to my next point, which is at a minimum, we should be entitled to jurisdictional discovery. This court has made clear many times, most recently in the Urquhart-Bradley case, that where the plaintiffs can show they may be able to supplement their jurisdictional facts, the court should liberally grant jurisdictional discovery. And we asked for that before Judge Leon. He did not respond. So,
and you want contracts? What is it that you want for jurisdictional discovery?
We want contracts, and we want the contract related documents that go to this question. All of the factual inferences that are being debated in the personal jurisdiction section, we want discovery on. So for example, how material was the US sourcing to the contracts? That is a question that I think discovery could answer. Did the foreign suppliers, to Judge Wilkins's question, did they in fact cooperate with their US affiliate manufacturers in fulfilling the contracts? We would want discovery on that as well. And just as a very basic matter, we want to see all the contracts themselves. One of the problems with what Judge Leon found was that some of the defendants, GE Healthcare, submitted no evidence whatsoever. Roche, to take another example, we alleged 4 contracts in the complaint. They submitted a declaration attaching 2 of the 4 and said nothing about the other 2. Yet Judge Leon, with this factual record, drew sweeping factual inferences, in my view, about whether the US sourcing was or wasn't material. And I would submit you can't even start to answer that question until we have all of the contracts.
And your theory that it was material, and when you talk about the connection to the tort, is, as you said, that it enhanced the value of the goods, it increased the ability of the defendants to get the contracts. What other meaningful affiliation are you referring to?
So, Judge Pillard, I think those are the most important 2. I would add a third, which is that the bribes were given in violation of a US federal statute and injured American citizens who felt injury in this forum. And I think that is a very relevant question that goes to the affiliation between the forum.
And that's FCPA. And what's the status of those cases?
Well, I'm sorry, it's not an FCPA issue, Your Honor. I was referring to the Anti-Terrorism Act, that Congress in Section 2A6 of the Justice Against Sponsors of Terrorism Act made a finding that these types of cases are vital to US national security. And so I think, of course, my friends say that's all irrelevant because that's just Congress trying to wish away a constitutional provision, but that's not true. I think if you read Ford, you'll see the Supreme Court placed quite a lot of weight on Montana's interest in hearing the controversy. And I would submit you're rarely going to find a civil lawsuit in which the forum's interest is stronger than in this one. Now, Judge Pillard, you asked me, I think, about the status of the FCPA criminal investigation. I believe that's where you were asking. I don't have a lot of visibility into that. I don't know. I know the defendants have said that it's been closed. What I can tell you is my understanding is that the key time period of our case, 2004 to 2008, was outside of the limitations period that I believe DOJ was working with under the FCPA. I think they might have had, there may have been issues with the beyond a reasonable doubt evidentiary standard. There may have been issues of prosecutorial resources. I just don't know. But what I do know is that Congress intended the Anti-Terrorism Act to provide a supplement to criminal enforcement. And whatever DOJ may or may not have decided about these allegations, I think should have no bearing on this court's decision about whether we have pleaded a cause of action under the Anti-Terrorism Act.
To the extent that your theory relies on notions of agency as between manufacturing defendants and supplier defendants, or even in Iraq, what law do we look to? You cite the restatement. Like, isn't there a complicated choice of law question there?
I would submit it's U.S. law because this claim arises under the Anti-Terrorism Act. So I cited the restatement because I thought general U.S. common law principles provide the best answer to that. Judge Pillard, to go back to one of your earlier questions, I can confidently say I think this one is not a question the court should reach in this posture. My friends devoted literally a half of a sentence to it in their brief. And if the court actually wanted to hear argument about whether the suppliers were agents of the manufacturers, we would have a lot to say. I don't really think that's a question the court should reach. But if you are inclined to do it, I would submit U.S. law is the place to look. I see I am very far over my time, so of course I'm happy to answer any other questions, but otherwise I'm happy to rest.
My colleagues have questions for Mr. Branson?
No.
Thank you. We did go over your time, but we will give you a short amount of time for rebuttal.
Thank you.
Mr. Shamigan.
Thank you, Judge Pillard, and may it please the court. Taking plaintiff's allegations is true. The district court correctly dismissed the complaint for failure to state a claim. At the request of the United States government, defendants stepped forward to help rebuild Iraq's nationalized healthcare system after years of neglect. Defendants manufactured or supplied life-saving goods to Iraq's Ministry of Health at a time when the United States government and many others were providing similar support. Yet plaintiffs in this case allege that by providing their goods to the ministry, defendants were knowingly supporting armed attacks on American soldiers by the Mahdi army, which stole those goods from the ministry. Plaintiffs have failed to state a valid claim for direct or aiding and abetting liability under the Anti-Terrorism Act, and they cannot cite any case permitting an ATA claim to proceed on even remotely similar facts. As to direct liability, plaintiffs' claims fail first because defendants' transactions with a legitimate sovereign ministry do not establish proximate causation under this court's decision in Owens 4. And second, because the supply of medical goods does not constitute a violent terrorist act, in the words of the statute, an act of international terrorism. And as to aiding and abetting liability, plaintiffs' claims fail first because defendants did not provide substantial assistance to the Mahdi army, and second because defendants were not aware of their role in terrorist activities. In addition, plaintiffs' claims are barred by the statutory act of war exclusion, and they cannot establish personal jurisdiction over the foreign defendants. A contrary decision would have a severe chilling effect on the willingness of companies and non-governmental organizations to conduct essential activities, often at the government's request, in troubled regions. The district court correctly dismissed plaintiff's complaint, and its judgment should be affirmed. Now, I'd like to start, if I may, with direct liability and then proceed to aiding and abetting liability. As I mentioned, there are really two issues here: proximate causation and the requirement that there be an act of international terrorism. On proximate causation, I think our submission is quite straightforward. Under this court's decision in Owens 4, which is consistent with the law of numerous other circuits, the presence of a legitimate sovereign intermediary breaks the causal chain. And the real relevant question for purposes of this analysis is whether that government entity was performing legitimate sovereign functions. Now, in this case, there's really no dispute that that is true, and we know that from the allegations of plaintiff's own complaint. In paragraphs 2 and 72 of the complaint, which can be found at pages 97 and 121 of the joint appendix, plaintiffs allege that the Ministry of Health was responsible for administering Iraq's system of socialized medicine. And there's no suggestion that the ministry was simply acting as a front for a terrorist organization.
Mr. Flanagan, under Owens 4, even if you have an independent intermediary, that just raises the need for a robust showing of proximate cause. It doesn't give an immunity anytime you have an entity that might have some legitimate function. Isn't that right? And the district court didn't go on to analyze that, but did just treat the governmental character of the Ministry of Health as a block to any finding of proximate cause. It isn't even just that under the terms of Owen 4 incomplete.
Judge Pillard, I think it's fair to say that the court in Owens 4 left the door slightly ajar. The court said that where the intermediary is a sovereign state, the need for additional allegations supporting substantiality, a substantial connection, is all the more acute. And our fundamental submission, and I think this is a fair reading of Judge Leon's order, is that the allegations here are simply insufficient to meet that high bar. We simply don't think that the allegations in the complaint match up to this characterization of the ministry as acting simply as a front or alias for Jaish al-Mahdi. At most, the complaint alleges that affiliates of Jaish al-Mahdi infiltrated the ministry, that some of the officials in the ministry were acting as agents of Jaish al-Mahdi, and the Jaish al-Mahdi or the Mahdi army was certainly using the ministry as an instrument in some instances to commit terrorist acts. We take all of that as true, but our fundamental submission is that that is not enough to make this like a case where you have, say, a charity that is acting as a front for Hamas or Hezbollah.
This is a very different situation from those in which you have a nation state that is the independent intermediary. And that's, I guess, Owens 4, Kaplan, where that I think your brief is leaning on, where it's a nation state, it's a government of an entire country. And the notion that that by being a state sponsor of terrorism, it is somehow equated with the terrorists that it supports, that seems to me a much more challenging obstacle to a finding of probable cause than, as alleged here, there is, even if you don't believe a full takeover and that there's some, provision of healthcare to people who are not anathema to the JAM affiliated folks who control the ministry. So they may be providing some legitimate healthcare, but this seems quite different from the cases on which Judge Leon relied, in the sense that as alleged, there's a major sort of terrorist function that's being sponsored. So I just, are there other cases or other ways that you can help us think about why, nonetheless, the agency character of the Ministry of Health should prevent a finding of approximate cause? Because that's the only holding really that Judge Leon made.
Judge Pillard, I would flip that around and respectfully submit that, if anything, this case is a weaker case for the reasons you identified. And let me explain why that is so. You are certainly right to note that in the other Court of Appeals cases that address this issue, the intermediary is typically one that has been designated as a state sponsor of terrorism. And indeed, in many of those cases, you have defendants who are actually evading sanctions regimes in order to transact with those foreign intermediaries. And yet courts have still said that that is insufficient. By contrast, here you have a government ministry, and there's no dispute that it's a cabinet level ministry within a sovereign government, but it's one that is actually being supported by the United States government during the relevant time period. And I would note parenthetically, because my friend Mr. Branson at argument, as in his brief, sort of strains to say that the United States government was somehow not supporting the ministry during this time period. I think that the allegation in paragraph 113 suggests otherwise. And to the extent that Mr. Branson is trying to insinuate that the United States government was dealing, only through other means, that it was not transacting with the ministry, I do think that that is belied by the government reports on which we rely at page 31 of our brief, and on which this court certainly can take judicial notice, that indicate the United States government was providing millions of dollars of support to the ministry and encouraging the defendants to transact with the ministry, which accords with the common sense reality here, which was that the United States government, in the immediate period after the fall of Saddam Hussein, was attempting to once again stand up the Iraqi healthcare system. But leaving all of that aside, Judge Pillard, even if you disagree with everything that I've just said, you're left with the fundamental problem that Judge Wilkins identified in his colloquy with my friend, which is that if you think that the plaintiffs here have sufficiently alleged that the ministry was somehow, a front for or an alias or an agent of the Mahdi army, you're left with a fundamental problem that the logical consequence of that would be that the United States government and anyone else, the United Nations, whoever else, who dealt with the ministry would somehow be responsible for proximately causing these attacks on American service members. Now, I think in an effort to avoid that implication, what plaintiffs are trying to do is to suggest, well, this is different because there is corruption involved, because the supplier defendants here somehow structured their transactions in a way to provide free goods to the ministry or bribes to Mahdi army terrorists. Now, I would vigorously dispute the characterization that the allegations here support corruption. And indeed, as Mr. Branson acknowledges, and as we point out at footnote 2, to the extent that the Justice Department was investigating those allegations, it has indicated that it does not intend to go forward with any further investigation. But leaving all of that aside, this is not an FCPA case. The question here is not whether corruption was taking place or even whether defendants knew that corruption was taking place.
Under Halberstam, though, it seems actually that our circuit has viewed, other illegality as relevant to the question, at least of aiding and abetting. I mean, in a way that on reading might even seem somewhat shocking that knowing about someone's apparent burglary makes you liable for murder. So I think, what's the pushback on that analog, which
so that goes
Congress
to the question
has clearly embraced?
Yeah, and Judge Pillard, I want to be very clear about how I'm signposting the issues here because they are obviously discrete. I think that goes to the issue of state of mind, both as an element of substantial assistance and also as a standalone requirement for aiding and abetting liability. My point here is simply that to the extent that plaintiffs are attempting to rely on these allegations of corruption as an effort to sort of get around the fundamental problem with their corruption theory, it just doesn't work here because there are insufficient allegations that this is a case where what was taking place was that defendants were somehow supporting Jaish al-Mahdi directly. And I want to say just a word about the allegations in the complaint, because this is such a central part of plaintiffs' argument. With regard to the free goods, the complaint actually at numerous points alleges that the free goods weren't even distinguished from other goods. And so, it's a little bit unclear exactly how the plaintiffs can allege that the free goods somehow were going directly to JAM and were bypassing the ministry. Indeed, the complaint itself alleges that this was actually a common practice, that to this day it still appears on the standard bid instructions. And as we explain in our brief, it's a common practice more generally as a way simply of providing a discount from the reference price for drugs that are being provided.
Although they would dispute that a discount from the reference price is something that's quite different and doesn't facilitate the evasion of inventory controls, such to the extent that there were any. That's a different move on the part of defendants.
To the extent that that's true, though, I think the plaintiffs still have the problem that in paragraphs 120 and 123, and I would note that the complaint is no model of clarity on this point, but at various points, the complaint suggests that the free goods were not being distinguished from other goods. And so to the extent that what plaintiffs are trying to do is to suggest that somehow free goods are going directly to JAM, I don't think their allegations get there. But I want to really
the
focus.
way, just reading it in the light most favorable to the plaintiff, I take them to be saying they're packaged all together. They arrive in a way that doesn't, that they travel in a way that doesn't single some out. In fact, on their telling, Jaish al-Mahdi has free play on the receiving end and can sell even things that doctors have said they need, sell them on the black market. But it's really, I think, a way for them of saying, maybe we would have a case if only the amount ordered were being sent, because the defendants knew or should have known that this was not a Ministry of Health, but a terrorist hotbed. But at least where they are sweetening the pot and sending goods that aren't, that are over and above, they're basically engaging in bribery of bad actors who they know will use that money for ill.
Well, a further problem with that, Judge Pillard, is that I really don't hear plaintiffs to dispute that their whole theory here is that these goods were being provided to the ministry. And then at that point, they were being looted or stolen, or whatever verb you want to use, by ministry employees who, in their view, were typically JAM agents. And that just underscores the fundamental causal problem with their theory. And before we get off this subject entirely, I do want to specifically address the allegations concerning bribes, because that was where my friend, Mr. Branson, started with his very first sentence. And those are obviously, the most lurid allegations in this complaint. And I think Judge Leon correctly found.
Oh, I don't know. I think there's some other allegations that have a higher claim to being lurid, but go ahead.
Can I say one thing about these so-called bribes, which is that Judge Leon, I think, correctly determined that there were simply insufficient allegations of that. And the one specific example to which plaintiffs point are these transactions by GE Healthcare, which plaintiffs rely on both in their opening brief and in their reply brief, these so-called $6 and $10 million bribes. I would invite the court to look at the relevant paragraphs of the complaint, and particularly paragraph 214 at Joint Appendix 188. The complaint does not allege a $10 million bribe. It alleges that there was a contract worth $10 million that, quote, caught the eye of investigators, and that the contract was linked to GE, quote, on information and belief. And I think that there are sort of analogous deficiencies with the allegation concerning the $6 million bribe. But I think that in fact, if you look at that paragraph, it's not alleging a $10 million bribe.
It actually is quoting a source saying of Dr. Zabili, saying that Dr. Adel took a $6 million bribe from a foreign company. All right. I mean, that's just what it says.
Yes, on contracts that one confidential witness understood to concern GE Healthcare. And so there I'm not disputing
but there is an allegation of a $6 million bribe from a foreign company.
Correct.
That's but pretty straight up.
But I think that the link to GE Healthcare there is fairly spare. And again, I make the point simply to sort of underscore, and the overarching point with regard to the so-called bribes, Judge Pillard, is that there's no dispute here that the complaint itself, and this is in paragraph 145, but also in paragraph 142, alleges that payments were made to Ministry of Health officials who were at most also members of JAM. There's no suggestion that payments are going directly to JAM. Now, I don't want to consume the entirety of our time on this one issue, but I'm content to sort of rest on the fundamental proposition that to the extent that this court left the door open to the possibility that there might be sufficient allegations in a case involving a sovereign intermediary, our fundamental submission is that these allegations simply don't meet that high bar. Now, I do want to turn to the act of international terrorism requirement, because a number of you had questions about that to my friend, Mr. Branson. And I think that while Judge Leon did not rest on that ground, Mr. Branson acknowledged that that's a pure legal issue that I think this court could comfortably resolve. And our fundamental submission on this is fairly straightforward. The definition of act of international terrorism is really meant to differentiate between conduct that can constitute primary or direct liability and conduct that can constitute secondary or aiding and abetting liability. And an act of international terrorism under section 2331(1) has to satisfy two requirements. First, it has to be a violent or dangerous act. And second, it has to be an act that an objective observer would conclude was intended to intimidate or coerce a civilian population. There are other potential intents, but that's really the relevant one here. And I think with regard to these sorts of claims of providing effectively material support, that these are at most fits for secondary liability and not primary liability. And the case on which Mr. Branson primarily relied today, as he does in his briefs, for the contrary view is the Seventh Circuit's decision in Boehm. Now, I think that opinion is frankly a somewhat confusing opinion. And I think it's fair to say that the court in that case seemed to really be straining to find a way of characterizing the conduct as primary liability because aiding and abetting liability was not yet available. But as the Seventh Circuit in Judge Wood's very lucid opinion in Kemper explained, that was a case in which the defendant was making a direct donation to a known terrorist organization. And that's obviously not the case here. And I think with regard to the objective intent requirement, all I would say is that the only thing that the complaint alleges is that the supplier defendants had a commercial motive, namely to grow their market share in Iraq. And I would once again point to Judge Wood's, very thoughtful opinion in the Kemper case, which held that very similar allegations were insufficient.
But a commercial, again, I'm just thinking about, the logic of these tort doctrines, like independent intermediary, it seems to me that one can concede that there may be some independence or some non-terroristic function going on at the Ministry of Health, and it might even be the intent of these defendants, the dearest wish that whatever they're doing stays within that lane. But, if there's a huge amount of terrorism also being sponsored out of that building with that staff, is the independent intermediary doctrine really applicable? That's one question. And then parallel with the commercial motive, sure, of course, these entities, these defendant entities are businesses, and they can say, look, we just want to do business. But is that a block against liability? Is that a defense if they're willing to exercise the commercial motive in a way that is knowingly providing support to terrorist organizations? And clearly not. So the fact that the recognition that there may be a commercial motive, or the recognition that there may be some sovereign function that even the plaintiff's complaint seems to acknowledge, I guess the question is just legally, can we at the complaint stage categorically kind of lean on that, or to what extent can we, and why?
So I think with regard to the act of international terrorism requirement, and Judge Pillard, I think we're really talking now about the second component of that, the objective intent requirement.
Are you talking about appears to be?
Yes, that is to say the requirement that the act be one that in the language of 2331(1) appears to be intended, and I'm ellipsizing some language, to intimidate or coerce a civilian population. I think that is something that the court can determine as a matter of law, as again, I think Mr. Branson acknowledged. And I think here our submission is quite straightforward, which is that transacting with the ministry is not an act that is intended to intimidate or coerce a civilian population, and not one that an objective observer would think was intended to have that effect. And again, you have to satisfy both requirements to have an act of international terrorism, and the act here simply was not an act that is violent or dangerous to human life. And that's why I think aiding and abetting liability would ordinarily be a more natural fit if the plaintiffs could satisfy the requirements for that. And the only other thing I would say on primary liability before we move to aiding and abetting liability is that I think with regard to the causation analysis, the manufacturer defendants do stand at a further causal step removed from the supplier defendants. And there simply are not allegations in the complaint, non-conclusory allegations in the complaint, to support the notion that the supplier defendants were acting as the agent for the manufacturer defendants. And so I think at a minimum, if this court were to disagree on primary liability, it should at least make that clear and make clear that the manufacturer defendants were
properly. Do you have a view of what source of law applies? I mean, it seems, just in common sense parlance, it seems pretty clear that if you're a manufacturer and you want to sell to a market, you work with a supplier to send your stuff there. I mean, it doesn't have to be day-to-day control in every aspect. We're not talking about a general agency to act in all respects. We're talking about the manufacturers getting these specific goods to these specific customers. Is there really any question that the suppliers are their agents for that purpose?
I don't think I would disagree with Mr. Branson's suggestion that this is governed by restatement type principles. My point is simply that the complaint, again, and we set this out in our brief, doesn't really contain any non-conclusory allegations of that. And there's undoubtedly, we're talking about proximate causation here, so there's undoubtedly a further causal step that would have to be satisfied as to those defendants.
Mm-hmm.
I do want to turn
you were
to
going on. Yeah, go ahead. You were going.
Yeah, I do want to turn to aiding and abetting liability because, while I said a second ago that I think that would otherwise be, a natural fit if the requirements can be satisfied. Of course, our fundamental submission is that there are two basic requirements that haven't been satisfied here. First, the substantial assistance requirement, and second, the general knowledge requirement. As to substantial assistance, we believe that Judge Leon correctly applied the Halberstam factors, which are, of course, incorporated into the ATA under JASTA. And I want to try to simplify the analysis here, because I think whenever a court has a multi-factor test like this, it can turn into a morass fairly quickly. I think I would try to categorize the factors here, into three. The first is the nature of the act and the kind of assistance. The second is the presence of defendants and defendants' relationship with the perpetrators. And the third is really the defendant's state of mind. I think with regard to the kind of assistance, plaintiffs really tried to run from the language that this court used in Halberstam. But the court repeatedly referred to whether the injurious act was heavily dependent on the alleged assistance, whether the assistance was essential or important to the illegal activities. Clearly, that was true in Halberstam itself. There's no question that Hamilton played an essential role in the overall criminal enterprise. But here there is no, but the whole point, of course, is that is not required as a matter of secondary liability. And this court, I think, correctly drew on principles from the aiding and abetting in the conspiracy context to say that you don't have to play a role in every single act of the criminal enterprise. Whereas here, there is an obvious mismatch between defendants' transactions and the Mahdi Army's terrorist acts. And the complaint really doesn't allege that defendants' transactions intensified the terrorist campaign. Indeed, the complaint itself alleges that Iran supplied the Mahdi army with its weapons. And so, again, I'm willing to acknowledge that that the plaintiffs don't have to show that the terrorist activities would not have taken place absent the assistance. My point is simply that this court has said that the conduct has to be important, essential, that the injurious acts have to be dependent on that assistance, and plaintiffs can't meet that requirement here. I think with regard to the second category of factors, the presence of the defendants and defendants' relationship with the perpetrators, I think plaintiffs all but concede that those factors favor the defendants. And that brings us to the defendant's state of mind. And I think here, once again, the plaintiffs are really struggling with the language that this court used in Halberstam. This court said that the defendants have to be one in spirit with the perpetrators. And while plaintiffs, I think, try to sort of file that down to a very generic knowledge requirement, that is language that courts in engaging in the substantial assistance analysis have routinely relied upon. And there's obviously no dispute here that defendants did not share the Mahdi Army's intention of harming American service members. Now, we think that the complaint fails plausibly to allege even knowledge, and I'll get to that in a minute. But I think for purposes of the substantial assistance analysis, this court in Halberstam was really, I think, drawing on principles in other contexts such as conspiracy to say that the real question is, does the defendant share the aims of the enterprise? And in applying that requirement in the Halberstam case, the court concluded that the defendant Hamilton's knowledge, quote, evidences a deliberate long-term intention to participate in an ongoing illicit enterprise. And so, Judge Pillard, while Hamilton may not have specifically intended that the murder be committed, the court nevertheless found that that factor weighed in favor of a conclusion that there was substantial assistance.
But even in a criminal case where a defendant is subject to aiding and abetting liability, let's suppose aiding and abetting first degree murder, the government, the prosecution doesn't have to prove if I hand a knife to someone and then that knife is used to murder someone else, they don't have to prove that I had premeditation and deliberation, kind of the same intent required of the principal. It's something less that the government is required to prove. And so saying the kind of one in spirit language in Halberstam, I mean, we can't take that too far, right?
I think that's a fair point, Judge Wilkins, and I don't think I would disagree with something that the plaintiffs said in their brief, I believe in their reply brief, which is that, you know, this is something of a sliding scale. This is, after all, a multi-factor inquiry. I just don't think that it's a one-way ratchet. In other words, I think that the absence of a shared intent here is significant. That's a point that other courts have, I think, attached significance to in engaging in the substantial assistance inquiry. It certainly isn't dispositive. And of course, you know, our submission is that to the extent that knowledge is sufficient to meet the independent state of mind requirement, that the allegations here fall short of the required level of knowledge. And I'm happy to turn to that because I do think that.
Yeah, I mean, that might be helpful. My question when you were characterizing Halberstam is it just seems that, you know, you're going to have situations in which you have corporate defendants, which frankly are really in it for the buck. And they're, you know, so they're not, you know, a deliberate long-term intention like the domestic partner of a criminal. No, it's not really a perfect fit, but the fact that they're really in it for the buck doesn't get them off the hook, where they're willing to go after that buck in a way that really is heedless to an ongoing, I mean, as alleged by these plaintiffs, an ongoing, obvious, open, violent, you know, campaign of terrorism. It's like, you know, not our problem. And then sending along the support. And so I guess if that were proved, and I know that your position is that these allegations don't rise to the level of even the way Mr. Branson would characterize them, but if you did have a case that presented a corporation in that position, you wouldn't be limited by Halberstam in the way you just described, would you?
If you had allegations that rose to that level, Judge Pillard, and I really don't think that the allegations in this complaint rise to that level, but if you did, it would obviously be harder for a defendant in those circumstances to make an argument that the requisite state of mind didn't exist. But let's go right to the state of mind requirement, because I do think that that provides an independent way of disposing of the aiding and abetting claims here. Now, first, what is that requirement? In our view, the proper understanding of that requirement is that a defendant has to be aware that it was playing a role in terrorist activities. Where do we get that from? We get that from the language of Halberstam itself, which says that a defendant must be, quote, generally aware of his role as part of an overall illegal or tortious activity at the time he provides the assistance. Now, I think the proper understanding here is that the relevant activity, the relevant illegal activity, is the terrorist activity. Now, my friend Mr. Branson relies on some language from the Second Circuit's recent opinion in Kaplan, where the Second Circuit slightly modifies that and says that a defendant may be liable if it was, quote, generally aware of its role in an overall illegal activity from which an act of international terrorism was a foreseeable risk. Now, I think that that's probably a somewhat imprecise gloss on the relevant statutory language. I really do think that the illegal activity is the terrorist activity. It certainly has to be the activity of the alleged perpetrator. But even if you accept that gloss, we think that that requirement is still simply not satisfied here. And I want to go directly to the sources on which plaintiffs rely for the alleged knowledge. Now, I think at bottom, plaintiffs are really relying on three things. They're relying on press reports, they're relying on visual cues, and they are relying, once again, on the allegations of corruption. Now, with regard to the press reports, we address these at some length in our brief at pages 54 to 55. Our fundamental submission is that there were no allegations of diversion of resources in the public domain at all until 2007, when the Deputy Ministry of Health was arrested. And I think even at that point, I think that the fair inference from the press reports was that the government was dealing with the issue of militia influence. But our submission is that these sorts of press reports are simply not sufficient to get to general awareness of the role in terrorist activities. And I would point this court to two Second Circuit opinions, the Siegel case and the Honigman case, for the proposition that these sorts of press reports in and of themselves are not enough. Now, as to, and I would note parenthetically that to the extent that Mr. Branson today relied primarily on a U.S. Embassy report for this proposition, this is at Joint Appendix, I believe, 123, that report isn't really helpful for scienter purposes because they're citing an internal U.S. government document that doesn't even appear to be available publicly. It's marked sensitive but unclassified. Leaving that aside, let's get next to the visual cues. And I think on the visual cues, our submission is that even if the complaint alleged that defendants' own employees actually visited the ministry, and the most of the complaint alleges is that some scientific bureaus that were allegedly agents of the defendants visited the ministry. But even if they did visit the ministry, and even if they did see these posters, that would not be enough to put defendants on notice that the Mahdi army was stealing and selling medical goods and using the proceeds to finance terrorist attacks, once again, particularly given that this was a time period during which the United States government was providing support. And to the extent that there are, allegations that there was a room with AK-47s in it, there's no allegation that anyone went to that room during the relevant time period. And so again, our submission is that these allegations of state of mind are weaker than those in other cases where the court has said that state of mind is insufficient. In the Siegel case, the defendant bank was aware of public reports of an organization's linked to terrorists, and indeed the bank itself was committing sanctions violations. And the court still said that that was insufficient to satisfy the general awareness requirement. And again, to the extent that plaintiffs point to the allegations of corruption more generally, the most that could be said is that would suggest, and I don't think it sufficiently does, but even if it were, the most that it would do is to suggest that defendants were aware of corrupt practices at the ministry, and not that defendants were aware that they were playing a role in terrorist activities. So I think that to the extent that the court has any concern about affirming on the ground that there was not substantial assistance here, and I do think Judge Leon's analysis of that was correct, the court can affirm on the ground that the state of mind requirement here was not satisfied.
Why do you think on the aiding and abetting that this case can be properly, assuming we're bound, can be properly distinguished from Kaplan? Kaplan distinguishes Siegel, so I'm not persuaded that your analysis of Siegel is in any way dispositive. Kaplan is a very strong statement against your position.
So
you and those on that side of this world cheered by the Second Circuit decisions before Kaplan. Judge Kearse really whacked you away on a lot of these questions on aiding and abetting. How can you distinguish? If I'm persuaded that Kaplan's right, at this point, what would your response to me be?
I think I would respectfully say, Judge Edwards, that this case is more like the cases that preceded and followed it, Siegel and Honigman, and less like Kaplan. And that is because in Kaplan, the party with whom the defendant was transacting was, persons who were known to be, in the words of the court, integral parts of Hezbollah, and who were so closely intertwined with Hezbollah's violent activities that one could reasonably infer that the bank had general awareness. And again, as we discussed earlier in the argument, I don't think that the allegations here rise to that level. And so we don't dispute that Kaplan came out correctly. Our view is simply that this case is more like the cases where courts have said that allegations are insufficient.
Mr. Shanmugam, that, and this is a very, very tough issue for courts because of the tremendous burdens of discovery. But, when there are allegations of state of mind, it's pretty hard to be, super definitive at the pleading stage about what your opposing parties knew, what kind of due diligence they did, what they uncovered when they did that due diligence, to what extent they were actually acting reasonably and really unaware, or to what extent they were on notice and putting their heads in the sand. And so, and as I said, I recognize that these are very difficult and frankly, issues that are hard to resolve in a satisfactory way because of the implications of opening the door to that kind of inquiry. But if the law is making state of mind relevant, consistent with the law, you think we can nonetheless demand more at the pleading stage?
I don't think we're asking you to demand anything more, Judge Pillard, but as I think as your question reflected, courts have not hesitated to dismiss these cases at the motion to dismiss stage, including on the issue of knowledge with regard to aiding and abetting claims. And indeed, the Siegel case and the Honigman case are both examples of that. And if a court applying the plausibility standard concludes that the plaintiff's allegations are insufficient, I do think that that is the right thing to do, particularly given the burdens of this type of litigation and the potential for really a challenging discovery. But the only other thing I would note with regard to state of mind here generally is that I think the issue of state of mind here has to be read against the backdrop that makes this case so fundamentally different from all of the other cases that we've been discussing. Namely, that during this time period, the United States government, far from labeling the Iraqi Ministry of Health somehow problematic or the equivalent of a state sponsor of terrorism, far from labeling Jaish al-Mahdi as a foreign terrorist organization, was providing support for the Iraqi Ministry of Health and indeed encouraging defendants to do so. And
you started your argument, Mr. Shanmugam, saying that these defendants answered the call of the United States. They stepped forward at the request of the United States government. And your citation for that, I'm sure it's in the introduction to your brief, but you're relying for that on what?
On government reports, of which I think that this court can take judicial notice. And I would point the court to page 31 of our brief, where we point out that the United States government encouraged companies to supply the ministry and even contracted with some of the defendants to supply medical equipment for ministry facilities, citing a report from the Special Inspector General for Iraq Reconstruction. And, again, I think that that is comfortably in the category of things of which the court can take judicial notice, not
Maybe
least because—
so. I'm sorry, I didn't mean to interrupt you. Not least because?
Not least because this court has repeatedly said that it is settled that the court can take judicial notice of records that reflect the United States government's official position. And that's all that we're asking the court to do, I think, consistent with the familiar standard from Rule 201. And I think that that's a really pretty modest proposition for the court to take judicial notice of. And I would note that to the extent that the plaintiffs seek to supplement their third amended complaint in this case with amicus briefs to try to sort of cast doubt on the nature of the United States government's support, I think the amicus brief on which they rely stands at most for the proposition that some within the United States government were concerned with corruption at the time, as they were before, during, and after the relevant time period. And for purposes of the state of mind requirements, again, the question is, did defendants know that by transacting with the ministry, that they were potentially supporting terrorist attacks on American service members, and leaving aside the obvious implausibility that these defendants would want to do anything to endanger the lives of American service members, an allegation that is obviously, deeply upsetting to these defendants. The fact remains that that is the touchstone of the inquiry here for purposes of aiding and abetting liability, as it is for purposes of primary liability with regard to the objective intent requirement we were discussing earlier. I know that the time is...
I just want to add one thing. Both Kaplan and Gonzalez rely on news reports for general awareness. So, I don't think you can sweep them away as quickly as you're doing. They clearly are making findings. So you may disagree with them, but they certainly have adopted an approach. And you're right, the earlier cases were very grudging, but Congress has amended in willingness to find liability. But Congress has amended the statute and has tried to give very strong statements as to what their intended purpose is. The purpose of Congress is sweeping. But one other thing, I'm just curious on this government support. It's an interesting argument. Are you saying these are mutually exclusive notions, that is, the existence of government support and the support of terrorists? If you can find the existence of government support, you cannot find support of terrorists? Because you're trying to get away with too much.
No, I'm not trying to get away with
that. No, I don't mean that in a bad. There's no bad intent, but I mean that given the world in which we're living in now, I think you and I could agree over cocktails. Of course, there are situations where the United States is probably supporting a piece of this, and there were parts of the ministry that were perfectly okay in what they were doing, and there's a part of that group, the ministry and those with whom they're hanging out, are doing bad things. And so you can have both U.S. support and you can have support of terrorism, right?
So I would say three things in response to that. First, Judge Edwards, I am not trying to argue for that sort of a bright line rule. My view is simply that the United States government's support is relevant to the analysis. Second, I take your point that plaintiffs now have two cases at the Court of Appeals level that have found allegations of knowledge to be sufficient, the Kaplan case and the Gonzalez case, which found allegations in part to be sufficient. But the allegations there were much more substantial. And in the Gonzalez case, with regard to the part of the claim that the court allowed to proceed against the social media companies, the court cited the fact that, quote, defendants allowed ISIS accounts and content to remain public even after receiving complaints about ISIS's use of their platform. So again, I think that the allegations there were more substantial. And my third point, and then I do want to turn briefly to Hezbollah and then personal jurisdiction, and I know that we've gone over time. But my third point, Judge Edwards, is that this brings us back in some sense to where I started, which is really the concern with permitting broad liability in contexts like this, where you have the United States government encouraging defendants to do business. If you permit liability under these circumstances, it is going to chill companies and non-governmental organizations from doing business in precisely the sort of troubled reasons that you were alluding to. If we were discussing this issue over your cocktail, we might be talking about what's going on right now in Afghanistan. You're going to have similar problems in other troubled areas of the world where parties are going to be concerned about potential liability for transacting with government entities. And that does actually bring us to the issue of Hezbollah, because the reason that there is a foreign terrorist organization requirement here is, I suspect, in part to provide some degree of clarity as to who you can deal with and who you can't deal with. And so while the foreign terrorist organization argument would not dispose of the entirety of the complaint in this case, because we acknowledge that there are at least some attacks as to which the complaint alleges some degree of involvement by Hezbollah, it simply can't be enough simply to inspire a non-FTO perpetrator or to train its fighters or even to provide weapons. If I say to you that it's a good idea to get married, no one would say that I was planning your wedding. even if I provided the ring to you, I don't think I could be said to have planned or authorized your wedding. And Judge Wilkins's example involving briefs is exactly right. While we would acknowledge that you could plan a campaign, that you could plan, a series of acts, there has to be a greater degree of involvement than simply inspiration or providing weapons.
Maybe
so that's
planning
why
a wedding is more complicated than planning the detonation of a penetrative missile.
Well, that may very well be true, but the mere provision of the missile is insufficient. And one thing we know is that Congress didn't use terms like material support. It required planning or authorization. And I think that tends to confirm that mere supply is not enough. Now, I do want to turn, because I know that we're well over time, just to personal jurisdiction in the last couple of minutes here, because I do think that should this court disagree with us on the merits here, that at a minimum, Judge Leon's dismissal on personal jurisdiction grounds was sufficient. Mr. Branson is certainly correct that the Supreme Court's decision in the Ford case makes clear that a causal connection is not required. But even in the wake of Ford, our fundamental submission is that there is an insufficient nexus between plaintiffs' claims and the presence of United States manufacturer defendants in the foreign defendants' supply chains. Now, plaintiffs have considerably narrowed their theory of personal jurisdiction on appeal. They're relying only on the allegation that the foreign defendants sourced from the United States some of the medical goods that they supplied to the ministry. But I think Judge Leon correctly determined that those forum contacts are incidental to plaintiffs' claims. The foreign defendants' liability here was rooted in their alleged misconduct in Iraq. It was not rooted in the sourcing of goods from the United States. Now, Mr. Branson suggested that Judge Leon got the legal standard wrong. I would encourage the court to look at the page that he cited. It's Joint Appendix page 818 or page 11 of Judge Leon's slip opinion. He does note that the plaintiffs do not allege that the foreign defendants' manufacturing or sourcing practices were themselves unlawful or could otherwise subject the foreign defendants to liability under the ATA, or otherwise that would be sufficient to establish personal jurisdiction. But then he goes on in the next sentence. He doesn't stop there, and he says, nor do those practices constitute the suit-related conduct underlying plaintiffs' ATA claims. And that's the fundamental problem here. At bottom, plaintiffs are really relying on a single allegation. It's the allegation in paragraph 153 of the complaint at Joint Appendix 158. It is incorporated earlier, I think, in paragraph 121, but it's the allegation that the Soderus, quote, placed a premium on importing medical goods manufactured in the United States and Europe, noting that other goods were more likely to be counterfeit. That is simply not enough. And this case is a far cry from a case like the Leachy case on which plaintiffs rely in their reply brief from the Second Circuit, where a U.S. bank account is really being used as the instrumentality of the relevant misconduct. And so we think that the mere fact that some of the goods were sourced in the United States is insufficient. And we don't think the jurisdictional discovery would affect the analysis, because the question here is
it almost sounds like, Mr. Shanmugam, you're going back to the causal test, because here there's no question that they were in fact sourcing vast quantities of goods from the US. And so it sounds like you're saying, well, their US-ness has to somehow be, their character as American goods, which, granted the plaintiffs have, as you say, also alleged that. But putting that aside, does it matter for personal jurisdiction, or is it required for personal jurisdiction that the American trade dress of these products be relevant to the terrorism allegations? Or is it enough that the suppliers are sourcing all of this stuff from the US?
So the question is there a tight enough relationship between the suit-related contacts, so here the US-related contacts, and plaintiffs' claims?
Yeah.
And our view is that even if you don't think about it in terms of causation, that the mere presence of US goods in the supply chain is insufficient. There's no dispute.
It's not mere presence. They're buying, they're taking US goods and and selling them in huge quantities. They are the instrument of this support for terrorism allegation. These are American goods. These are companies that are, the suppliers are, benefiting in the selling of these goods in Iraq. They're benefiting from the protection of US contract law, from the protection of US food and drug law, from the protection of US intellectual property law. And all of these, that's how they make their business, is that they're selling US goods in other countries. And so I guess I'm missing why the potential, the questions that you raise about the terrorists particularly liking American goods, like put that aside. Is there a question about personal jurisdiction even if we didn't have those allegations?
Well, I think what we know, I think we can't say, how much of these goods were sourced in the United States. I think I take that point that on this record, we don't know the answer to that question. What we do know is that many of the contracts did specify other countries as the source of origin for the contracted goods. But our submission is that I think for legal purposes that doesn't matter. In other words, that the exact quantification, which seems to be what Mr. Branson would want from jurisdictional discovery, wouldn't somehow establish a tighter nexus between the United States and plaintiffs' actual claims here, which again do not depend in any way on the fact, as a legal matter, on the fact that the goods are being sourced from the United States. And so again, I think at a minimum, it is not the case that Judge Leon adopted a legal test that turns on the unlawfulness of the United States conduct. And because he applied the correct legal test, we believe that he in fact reached the correct result, and that is true even in the wake of the Supreme Court's decision. Unless the court has any further questions, I think I would just sort of close where I began. And it goes without saying that the defendants here condemn the attacks on U.S. service members in Iraq and sympathize with the plaintiff's plight here, with their desire to hold someone accountable for the injuries that they and their loved ones have suffered. But as Judge Wood said in her opinion for the Seventh Circuit in Kemper, this is a case in which my clients are simply the wrong defendants, and there's no valid legal theory on which they can be held liable, either as a matter of direct liability or aiding and abetting liability under the ATA. And unless the court has any further questions, we believe that the district court correctly dismissed those claims and that its judgment should be affirmed.
Thank you. Mr. Branson, if you would like it, you can have, given the length and the complexity of the issues, you can have 4 minutes for rebuttal. You're on mute.
Thank you, Judge Pillard. And Judge Edwards, I'd like to start with your question. You are exactly right about Kaplan. Judge Kearse rejected virtually every legal argument that my friends have made on aiding abetting liability. And Mr. Shanmugam attempted to distinguish it by saying that the intermediaries there were integral parts of Hezbollah. That's their argument. That was plaintiff's characterization in the complaint, sourced primarily to anonymous, undated websites. That is why the Second Circuit accepted that characterization. And I think all this court needs to do is compare paragraphs 78 to 79 of the Kaplan complaint, which were the basis of that characterization, with paragraphs 165 to 187 of our complaint. It's no contest who has more detailed allegations to draw the inferences that Judge Kearse properly drew in Kaplan. And I would just note that the lead intermediary in Kaplan was the Shaheed Foundation. The defendants argued vehemently, just like Mr. Shanmugam just did, that was a medical institution that built hospitals and provided medical services to orphans. That's what the defendants said in their brief. But the Second Circuit accepted the allegations in the complaint because it's a motion to dismiss. And if this court does that here, the logic of Kaplan, which I think is very persuasive, dictates a reversal. Mr. Shanmugam also said repeatedly that the US government encouraged them to do these transactions. There is not a shred of evidence in the joint appendix that says that. I'm happy to walk through every document that they've cited. I've read every one multiple times. There's no evidence of that. The best Mr. Shanmugam has is this vague spreadsheet from a Special Inspector General for Iraq Reconstruction report at JA, I believe, 691 to 96. Those are talking about direct US government contracts where the US ran the procurement and then supervised the installation of the goods and the services as part of its effort to rebuild Iraq's health infrastructure. And their own lead amicus in an interview given to the Special Inspector General for Iraq Reconstruction acknowledged the difference between the two. So this idea that the US government asked the defendants to sell to Kamadia, it's not true, and there's no evidence of it. And that's even assuming the court should take judicial notice of these reports, which I don't think it should. I mean, most of them are these anonymous weekly reconstruction update documents that I've been unable to authenticate. We've served FOIA requests on USAID to find them. USAID can't find them. The defendants downloaded them from some third-party website. For all I know, they were written by an intern in USAID and never made public. So the idea that in a case of this magnitude, the court should find what official US policy in Iraq was based on anonymous newsletters that nobody's been able to authenticate, that's not what this court should do. By contrast, here were the facts about the US government in Iraq. By 2007, US officials could not even go into the ministry building because it was too dangerous and they were getting death threats. That's paragraph 180 of the complaint. We've spoken about the military operation to arrest and prosecute Hakam Zamali, who was these defendants, essentially their counterparty and one of the worst terrorists in Iraq. That's paragraph.
I hate to interrupt when you have limited time and you're clearly trying to use it efficiently, but when you talk about the agents of the defendants or the defendants, it's a little bit unclear in the pleading, going into the building. As you've said, Americans couldn't go in. I assume that you're talking about the Scientific Bureau. Is there any reason to think that if the Scientific Bureau, who I understand to be local Iraqi people that are working on behalf of the defendant companies, any reason to think that they would communicate back how many AK-47s they saw leaning against the wall, or whether they saw Death to America posters on the wall or anything like that?
Yes, I mean, the scientific bureaus were their local agents in Iraq responsible for these businesses' relationship with the ministry. So yes, there is entirely plausible reason that they would have reported it back. But I would also note, Judge Pillard, we've alleged that they were agents. That's paragraph 158 of the complaint. And so, an agency relationship, the knowledge is imputed to the principal. So even if there was not a communication back to the companies themselves, and to be clear, we're entitled to discovery on that. That is not an inference this court should resolve on a motion to dismiss. But we don't think we need that because as a matter of fundamental agency law, the knowledge was imputed. And I would just stress that for all of Mr. Shanmugam's discussion about knowledge, Judge Leon went as far as to say there was knowledge at JA 835. I quoted that in my opening brief. He said that the defendants, quote, were aware that their goods, quote, would be used by Jaish al-Mahdi to support terrorist attacks, as alleged, of course. And so this knowledge issue, again, I think Judge Edwards had it right. I mean, you compare the knowledge allegations here to the ones in Kaplan, and I think the case needs to be reversed. On Hezbollah, just very briefly, Mr. Shanmugam characterized our allegations as merely providing the weapon or merely giving inspiration. That's not what we allege. Yes, they did provide the weapon, but they did a lot more than that. They trained them how to use the weapons. They had operatives on the ground dictating day-to-day tactical decisions about how to use them. They encouraged Jaish al-Mahdi to use these weapons against Americans in Iraq. And that is why I think the easiest way to see this is at paragraphs 395 to 96 of the complaint, talking about these explosively formed penetrators. The idea that all Hezbollah did was give them the weapons and nothing else, that is not what we allege. And at a minimum, Judge Wilkins, I know that you had some questions about how to draw the line on this, and I acknowledge that there are going to be hard cases at the margins. I would encourage the court, if it's concerned about that, to draw those sorts of lines on a summary judgment record when the factual record has been fully developed. Because I think no matter what the legal test is, and I would note that my friend didn't actually articulate what he thinks the test is. I'm surmising he thinks that it means that a Hezbollah person has to show up to the street corner and point, blow up this bomb and kill that tank. If that's the test, and I don't think it is, we're entitled to discovery because we have at least alleged a plausible nexus between what Hezbollah did and each individual attack, such that discovery may well yield the sort of evidence that I think my friend is demanding.
I'm going to let you go,
Okay.
but what are the best responses to the concerns that many voice in opinions and in the argument today about casting a net so wide that entities or individuals that really want to provide humanitarian aid to people in distress, of which there are many in areas that are under terrorist control or besieged by terrorists, that they would be snared in this law?
Well, Judge Pillard, it depends on what the facts are, of course. I think if all, and I'm thinking of the charities amicus brief that the other side submitted, if all you're doing is providing humanitarian assistance in an area that has terrorists in it, that's not going to be enough to create liability. I mean, the statute, I think my friend quite rightly said, has two key elements. You need substantial assistance and you need general awareness. And those are not easy bars to meet. I think they're met here by the complaint, but it's not as though every charity in the world is going to be subjected to a lawsuit like that. And I think there's been no showing that there would be. To create an action under this statute, you have to substantially assist terrorists that are attacking Americans. And I guess, Judge Pillard, I'd close by saying this law is broad, and it's because Congress really doesn't like it when companies fund terrorists. And so, there may well be some competing policy considerations that might rear their head in some future case. But very heavy in the calculus is Congress's determination that you shouldn't fund terrorists. And when you do, that is an extraordinary interest that Congress was entitled to legislate against. And I think when you apply this statute to these facts, the case should be reversed.
Thank you, counsel, both of you, for a very able argument in a very difficult, not just legally, but in other ways, very difficult case. Case is submitted.
This honorable court is now adjourned until Wednesday, September 22nd at 9:30 a.m.